meeting of the Howell Township Planning Board to be open, adequate notice having been given pursuant to the Open Public Meeting Act in the following manner. First, on March 31st, 2023, a copy of said notice was mailed to the Asbury Park Press and the Star Ledger. Second, on March 31st, 2023, a copy of said notice was hand-delivered to the clerk of the Township of Howell. Third, on March 31st, 2023, said notice was posted in the office of the Planning Board and on the bulletin board in the Howell Township Municipal Building, 4567 Route 9, Howell Township, New Jersey. In accordance with the Fire Prevention Code and your safety, please be advised that this facility is designed with 2 emergency exits which are on the right at the front and rear of the meeting room. Furthermore, smoking is not permitted in the municipal building. Please take note that this meeting is being videotaped for possible future broadcast on Howell Township TV 77. Thank you.
Roll call, please.
Mr. Cristiano has been excused. Mr. Greenfield?
Here.
Mr. Husser?
Here.
Mr. Leggio?
Here.
Mr. Seaman?
Here.
Mr. Tannenhouse?
Here.
Councilman Gager?
Here.
Mr. Mercer?
Here.
Ms. Pike?
Here.
And Chairman Bavai.
Here.
You have a quorum.
Thank you. Okay, so right now we're going to stand for the Pledge of Allegiance and then a moment of silence for the troops serving here and abroad. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do we have any minutes?
I have no minutes.
Do we have any vouchers?
No vouchers.
Do we have any correspondence?
Yes, I have an email from Mr. Pape. He is the attorney for the second application on tonight, which is for Lowe's Companies. He asked that that please be rescheduled to November 2nd, and he will renotice and republish for same.
Okay.
Because there's going to be a renotice, there's no announcement that's necessary then, Mr. Chair.
Okay, thank you.
And that's all the correspondence
That's
I have.
All right, so we'll move right to resolutions. First resolution is case number SD 3010, Samuel Niger. Eligible voters, Greenfield, Hooser, Leggio, Seaman, Gazer, Mercer, myself. Can I have a motion?
I'll make a motion to memorialize.
Second.
Who was that, Mr. Tannenhouse? No. Mr. Mercer, thank you. Mr. Greenfield?
Yes.
Mr. Husser?
Yes.
Mr. Leggio?
Yes.
Mr. Seaman?
Yes.
Councilman Gager?
Yes.
Mr. Mercer?
Yes.
And Chairman Bavai.
Yes.
Motion carries, resolutions memorialized.
Okay, next one's case number SP 1046A, Bank of America, resolution granting submission waivers, eligible voters, Greenfield, Hooser, Leggio, Seaman, Gazer, Mercer, and myself.
Make a motion to memorialize. Second.
Mr. Greenfield?
Yes.
Mr. Husser?
Yes.
Mr. Leggio?
Yes.
Mr. Seaman?
Yes.
Councilman Gager?
Yes.
Mr. Mercer?
Yes.
And Chairman Bavai.
Yes.
Motion carries, resolutions memorialized.
Okay, next one's case number SP 1115, JABE Howell LLC, resolution granting submission waivers, eligible voters, Greenfield, Huzar, Leggio, Seaman, Gazer, Mercer, and myself.
Motion. Second.
Mr. Greenfield?
Yes.
Mr. Husser?
Yes.
Mr. Leggio?
Yes.
Mr. Seaman?
Yes.
Councilman Gager?
Yes.
Mr. Mercer?
Yes.
Chairman Bavai.
Yes.
Motion carries, resolutions memorialized.
Thank you. And we don't have any submission waivers tonight, do we?
No submission waivers.
All right, first application up is case number SD 2997A, Larrabee Realty LLC.
That one has been carried. That's the one that we carried to,
No, Lowe's will be carried.
oh, I'm sorry.
Good evening, board members, board professionals. My name is Jared Pape. I'm an attorney with the law firm of Howell Pape, appearing on behalf of Larrabee Realty LLC. We are requesting an amendment to a condition of a resolution that was adopted by this board. This board adopted the subdivision resolution was memorialized January 6, 2022, creating two residential building lots. The property contains currently one single-family residence, which is going to be removed, which was also memorialized in the resolution. When the subdivision was created, there was a variance condition that was also created with regard to a side yard setback for that existing residence. It was called a temporary variance in the resolution because that structure is ultimately going to be removed. Condition number 4 of the resolution states that the temporary variance relief shall only last for 12 months from the date of the resolution. So that expired January 6, 2023. So we're here requesting an extension, essentially, of that condition as the house is still there. Due to prevailing economic conditions, our client's construction timeline has been delayed. I'll note that we had originally filed this application back in March. Obviously, it's now October, so we would be, the one-year extension only brings us to January of 2024. For that reason, our client's preference would be to build a little flexibility. And if we could extend that an additional 6 months, that would be our preference. So that would bring us to July of 2024. And that's what we're here requesting.
Okay.
Do you have a timeline?
We don't have a hard timeline, but our client anticipates that by the spring, that the existing structure will be removed.
So you basically want like an 18-month extension?
Correct.
Mr. Chair, I take no exception. I understand the issues.
Yeah.
And, I mean, Laura, you have a letter. Do you have any issues?
No issues.
Yeah. Anybody on the board have any, I mean, he did file it in March, and our schedule's been so jammed up.
Yeah.
Doesn't seem unreasonable. So, I mean, if nobody has any objections, I mean, can I have a motion?
Get
No,
over
we
it.
have to
wait,
open it
wait.
up to the public.
Got to open up, you're right. All right. Right now, we'll open it up to the public. Anybody has any comments or question about this? Okay. Seeing that there's none, I'll close the public portion. And,
You want a motion?
yeah, I'll entertain a motion.
Okay, I'll make a motion to approve case number SD-2997A.
Second. For 18 months.
Yes.
And that was Mr. Greenfield seconded?
Mr. Seaman.
Mr. Seaman, thank you, sorry. Mr. Greenfield?
Yes.
Mr. Husser?
Yes.
Mr. Leggio?
Yes.
Mr. Seaman?
Yes.
Mr. Tannenhouse?
Yes.
Councilman Gager?
Yes.
Mr. Mercer?
Yes.
Ms. Pike?
Yes.
And Chairman Bavai.
Yes.
Motion carries.
Thank you.
Thank
You.
Have a good night. Okay, next up, case number SP 1105, AAVRHW Property LLC, Victory Road.
Hey, just before we get started, Mr. Chair, I know we have some recusals. Is that correct?
That's correct.
Yes.
I'll be
Mr.
recusing
Tannenhouse
myself,
and
Mr. Chairman.
Councilman Gager.
Nice seeing you, man.
Okay, so let's just mark the recusals in the minutes, and if those recusing could step off the dais.
And Ms. Pike has certified to be eligible to vote on the application.
That was going to be my next question. So everybody sitting tonight is eligible to vote?
Yes.
Okay.
And Ms. Pike, I left the memo there. If you just sign this for me and give it back.
You have to.
Okay, so just, by way of housekeeping, the way we start most of these hearings, I know that we have multiple attorneys. If all the attorneys could just enter their appearances and identify the clients that they're representing.
Thank you, Jack.
Sure, is it okay if I sit here?
Yeah.
That's a microphone right in the middle of the
Right
table.
here, right?
Yes.
Okay. Good evening, ladies and gentlemen, the board professionals, Rob Simon on behalf of Harold Law, here on behalf of the applicant AAVRHW Property LLC, Block 41, Lot 17.
Counsel?
Good evening. My name is Brittany DeBoard. I'm with Lieberman Blecker.
Is she close enough to
No,
the mic?
you have to sit.
Yeah,
there's
you can have a
mic
seat.
Is that a mic?
Yeah, that's a mic.
Oh, okay. And here is good? Do you?
Yeah.
Okay.
Yep.
That's fine.
My name is Brittany DeBoard. I'm with Lieberman Blecker and Sinkovich. I represent the objector neighbors.
Can you just list them?
Oh, gosh. Can I say Betty Velez et al.?
No.
Hold on. I just want to make sure that the list we have is accurate.
Sorry,
Eileen is
there are a
getting
few.
it.
Do you all have a list? Okay.
Oh, and then, O3 has the names as well, so they're all.
Eileen, if I pull up 01 too, because I think there were some names on that as well.
So we have, Marjanis, Barzelli, Chris Bates, Justin.
Sorry.
She stepped away.
Yeah, I agree with you. Also, some of you guys that know that.
Can we show that up on the screen? Yes. Somebody showed up on the screen and just have her read it off the screen.
Thank you, Laura.
I think we're going to be able to get it up on the screen.
Perfect.
If you could just read it off the screen and then tell me if you got anybody else.
Okay, all right. Can we zoom in a little bit?
Yeah.
There's one right there. Oh, thank you.
There's multiple emails and lists, so. Three is the expert witnesses. We don't need that, just 1 and 2.
So let's start with one.
Alrighty. Alrighty, the clients are Marjanis Garcelli, Chris Bates, Justin Gumley, Diane Lindstrom, Francis Santore, Betty Velez, Edwin Woolley, and Marie Woolley.
We have some more also on another exhibit.
Multiple Ps.
You can pull up over two.
I said multiple Ps.
As well as Marianne and Robert Wagner.
Okay. And that's still accurate as of today?
To my knowledge, yes.
Okay. All right, before we get into the substance of tonight, since the last time we had a public hearing, we did receive several letter briefs, both from the objector's attorney and the applicant's attorney. The objector's attorney has raised an issue as to jurisdiction, which I think the board needs to resolve before moving forward. Counsel, if you want to place your objection on the record.
Yes, please. So we have a jurisdictional issue here with this application, and it precipitated from an off-site improvement that was proposed at the last hearing. My understanding is that the improvement is necessary for the warehouse to operate as proposed before this board, and it is a improvement and access way proposed on a private property at the corner of Victory Road and Route 547. And it's not just an access way or an improvement to the public right-of-way. It's an improvement on the private property that I believe is a auto body shop. This access way is an accessory to the warehouse, and case law, which I won't belabor the point, but I'm happy to answer any questions. The case law.
Counsel, you can feel free to cite the case law. I want to make sure we have a complete record.
Great, and I will. But the case law indicates that such an improvement should be considered part and parcel to the application, even if it's off-site, and it's considered to have the same use as the application, which is a warehouse. So what we're dealing with is an off-site improvement that's considered part of the warehouse on a private property in a different zone than the primary property zone, and that's in a ARE6 zone. None of the neighbors surrounding this property were noticed. This will cause a significant change for these neighbors. As I understand, it will facilitate truck traffic. That in and of itself, I believe, causes a jurisdictional stopgap for this application. In addition to that, by virtue of the fact that this is a different zone, the rural zone, warehousing is not permitted in this zone, which causes this application to need a use variance before the zoning board. So I'd respectfully submit that we're in front of the wrong board now. My final issue, and this is an issue that I was just made aware of, my understanding is that the developer intends this space to be more of a flex space. The developer has added a number of office spaces to this warehouse development and has discussed this development as a flex space. That is not a permitted use in this zone, in this SED zone. Flex space is permitted in other zones such as SED2, not in this zone. It's yet another jurisdictional issue where I would submit we're before the wrong board.
Okay, counsel, do you have a response to that?
Mr. Kuchera, thank you. So, as this board is aware, all these contentions began via counsel's correspondence to this board on or about August 10th.
I can't even hear.
You can pull that closer to you.
Can you hear me? I will speak up. I apologize. I will go right in front. So, as this board is aware, professionals are aware that these issues that council has brought up tonight were initiated via correspondence on or about August 10th, 2023. Our office provided a written response dated August 16th, 2023, that we rely on in opposition to these so-called contentions. There was then a response dated to my letter of August 16th, and my recollection is that other counsel, Mr. Gazarovski in particular, I believe, submitted his own letter in opposition to these contentions, I believe also dated August 16th, 2023, and I believe that counsel provided a follow-up letter on August 17th of 2023. Now, their contention that this right-of-way improvement a half a mile away constitutes a driveway for a warehouse that is part of this application as and I believe the quote was, an integral part of the ingress and egress of the warehouse, and that the applicant is proposing a warehouse use on what will become a public right-of-way widening is, and I don't use this word lightly, ridiculous. And it's also, and I don't definitely use this word lightly, frivolous as a matter of fact and as a matter of law. First of all, this board is aware, well aware, that has no authority to deny a site plan for permitted use because of any anticipated detrimental impact on off-track traffic conditions. That's the Dunkin' Donut case, and I believe we actually cited to that early on with regard to these proceedings. This easement would become part of a public right-of-way improvement once offered by an applicant, in this case, our client, but it needs to be accepted as such by the township and the county, and it needs to be required by this board. And even if all those things happen, what do we have? We have nothing more than an off-track improvement that is contemplated in the municipal land use law in section 42. By definition, an off-track improvement means not located on the property which is subject of a development application, nor on the closest half of the abutting street or the right-of-way. And that's based on the ordinance, the municipal land use law definitions in section 5 of the MLUL. They then double down, they being the objectors, and they say, oh, well, you know, we have case law to support this. We have the Brower case and we have the Knuckle case. Well, in the Brower case, the issue is whether notice was needed to be provided to property owners within 200 feet of property that was to be used by the applicant as a secondary access road to that development in question that went through multiple private properties. And in fact, in that case that I'm well aware of, for reasons I don't need to get into, it comprised approximately 20% of the actual traffic to that site. That's the Brower case. And the court in Brower characterized that second adjacent roadway not as an off-track improvement, but rather an off-site improvement, which was located outside the lot lines, but within the property of which the lot is a part, which is subject to the development application. So we're not, so in Brower, the secondary access road to the site was determined to be part of the property and therefore required public notice. And in Knuckle, the issue was whether a developer who proposed to place a private driveway on a lot to service a hotel on an adjacent lot was required to obtain a variance since that adjacent driveway was to provide the hotel with highway access. Neither one of those cases is remotely close to the facts of this case. We're not building a new road as part of this project. We're not building a new driveway a half a mile away as part of this project. We're not connecting either a new road or a new driveway, let alone 1.5 mile away, directly to our development. All we're doing here is just proposing, if required by the board, to widen a very small portion of an existing public right-of-way contained within an intersection located, again, a half a mile away as a public safety benefit that will be usable not just exclusively by this development or those who are accessing this development, but by the general public. The need for public right-of-way widening improvements, sometimes, of course, in more than one location, frequently arises during the course of a development application. Those public improvements are never part of the application notice. They're never considered for part of jurisdiction purposes. And here, instead of criticizing, there should be an accommodation, because what the applicant did here was proactively and voluntarily respond to concerns raised by the board members during this application proceeding by securing those off-track rights under an easement to widen and enable improvements to the existing intersection of Victory Road and Lakewood Farmingdale Road. We testified and we provided evidence that we do not believe that any of the trucks in the development will be making that right-hand turn in the first place. And that's actually not necessary to provide the easement for approval of the application. However, if the board determines that the easement is necessary and it's accepted by the township, accepted by the county, under those circumstances, the applicant is then willing to pay the full cost of the contemplated improvement. So regardless of whether the board requires the intersection improvements a half a mile away from the property as contemplated by the easement, regardless of that, those easement rights were not required to be secured prior to any vote on this application. And the easement has nothing to do with direct access to or from the property or with providing utility or other services to the property. It was secured in advance on a purely voluntary basis to benefit not only the applicant but the entire community. And we do contend that it is not only unprecedented, not only ridiculous, but yes, frivolous, with no legal support whatsoever to make these claims. I also am forced to respond. There was another letter that was submitted 2 days ago.
Well, let's
Yeah, go ahead.
go with the first two issues.
Yep.
The second issue that council raised had to do with perhaps the evolution of the use that's being proposed. Do you have a response to that?
Well, so there was without providing any written support or advance notice, they're making a claim that this is an application for flex space and that flex space is not permitted in the zone. This is a warehouse application. The application is what was submitted by this board. There's been no comment about the fact that warehouse use is a permitted use in the zone. This is an application that does not require any form of use variance. It doesn't even require any form of bulk variance. And to say that, oh, well, I heard things, and that now we believe that this is a flex application, and therefore it is not permitted in this zone
Well,
is
council,
not
just a
accurate.
question. Is there a plan that has been submitted that increased the number of office spaces as asserted by the objector?
Any plan that was submitted, that plan, actually, we're not going to be relying on that plan.
I don't understand that.
So we submitted in advance as a courtesy to this board, exhibits that we may decide to rely on with regard to the application. We're not relying on that plan. We have not introduced it by way of any testimony or
The
witness.
plan that you testified to,
The plan that we testified, you mean the prior plan that we testified to? What are you talking
what am I talking about? You come here, you filed an application.
about? Right.
The objector claims that the number of office spaces has increased
It-
since you filed the application. I'm asking you, is the application the same in terms of the number of office
I
spaces?
apologize, I misunderstood your
Okay.
question. Yeah, it's the same.
Okay. We'll get to the most recent letter after we deal with these jurisdictional issues. Counsel, do you have anything else you want to add?
With regard to the access way, I guess my question is, who is benefiting from this access way? I strongly, strongly doubt that the developer is doing this solely out of the goodness of their heart. And in fact, why would they include this access way as a component of their application if that were the case? The Broward Development Corp case is, in my opinion, spot on. It addresses an access road that serves a development, an off-site access road, and the question isn't, are we parsing out the size of the access road or what it does? The question that the court was asking was this, with respect to notice. Will the people around this off-site property be significantly affected by its construction? That was the question in the Broward case. The court decided that it was, and that the people around the other lot needed to be noticed because this was an important component that would significantly impact them that was part of the primary development. This is the same case here. The people around this intersection area should be noticed. This is a lot that is grandfathered in. It's not even consistent with the use of the zone. It's a rural zone. It already has too much impervious on this lot. In any other situation, if that private owner was going to add impervious to the lot, they would need land use approvals. Just because this is an improvement to a public right-of-way, it encroaches on private property, and it does not absolve the developer of complying with the land use regulations. Just doesn't. They still need a variance.
It's a complete,
Well,
okay, I'm sorry.
let counsel finish.
Yep.
In short, that's my conclusion. The developer cannot get around the land use code and propose a component of its application and simply say that these people shouldn't have been noticed and that they don't need to worry about compliance with the land use regs. It's part and parcel of their application. And I will say, if the board decides to continue with this application, I would ask that we be permitted to obtain testimony about how necessary this component is to the application, period.
This is a legal issue.
I know, but she said the rural zone. I'm just trying to clarify what zone.
ARE6.
Thank you.
That is, respectfully, it's a complete misreading of the Brower case. The Brower case involved an easement that was directly next to the development in question. And the court said that because it was an on-site improvement, not on the lot but within the development, it required notice. This is an off-tract improvement, which is very different. It's governed by Section 42 of the Municipal Land Use Law. It's a half a mile away. It's not a new road. It's not a new easement. It's just roadway widening in response to concerns raised by this board. And that is it. It has nothing to do with this application in terms of conferring jurisdiction for purposes of permitted uses, for purposes of notice.
Okay. Mr. Chair. So I read all of the various letter briefs, looked at the case law, have listened to the arguments today. I would first counsel the board to not consider the characterization of the arguments, words like ridiculous and frivolous. That's not anything this board needs to concern itself with. It's reviewing the merits of the arguments. They've both been well argued. I did take a look at the Brower case. I was familiar with it, and the Knuckle case. We also looked at the cases where these cases have been cited, like the J-Star case, Conti v. Smith, Lakewood Realty Associates, the Angel case. And what these cases have in common is that they involved access drives that were very direct. They were on adjoining properties, and they were direct to the property that was the subject of the application, and the purpose of it was to provide access solely to that property. Here, the improvement is not the same, or the proposed improvement is not the same. It is not on an adjacent property providing an access drive simply to this property to facilitate ingress and egress to this property. It's a traffic improvement some distance away, and everyone that drives the road is going to be able to use it. It's not anything that is necessary to ingress and egress of the property where it would become part of the application. So I find that in my counsel to the board, in my recommendation to the board, is that Brower and Knuckle are distinguishable and do not require a 200-foot notice from that property. Ancillary to that argument is whether there needs to be a land use approval on that property. That's not before this board. So, there may be a time when permits are being sought and there are changes to that property, and there may be the need for a land use approval. We'll see if and when that happens. So that's my recommendation. My recommendation is that those cases do not deprive the board of jurisdiction. On the secondary issue, I don't know what the banter is about in the community. I don't know what goes up on websites or what people say to each other or what may be contemplated in the future. What I do know is what's being applied for. And what's being applied for is not what council was talking about, a flex use with the extra offices. That's why I asked the question whether the application had changed. I don't know what the applicant wants to do in the future, and quite frankly, it's none of this board's business at this juncture. There's an application that's before the board. That's the application that we consider, not an application that might be hypothetically coming sometime in the future. So I feel on both of those issues that the board has jurisdiction. Mr. Chair, if the board wants to take a straw vote on whether it believes it has jurisdiction or not.
Yeah, we certainly can do that.
So having heard the arguments of both counsel, Actually, we'll take a formal motion. Is there a formal motion that the board determines that it still retains jurisdiction?
I need a motion.
I'll make a motion.
Can you turn on your mic because I didn't pick it
I'll
up?
make a motion.
Thank you.
I need a second.
Second.
Mr. Greenfield?
Yes.
Mr. Husser?
Yes.
Mr. Leggio?
No.
Mr. Seaman?
Yes.
Mr. Mercer?
Yes.
And Chairman Provide.
Yes.
Motion carries.
Mr. Simon, could I just ask you, if you remember the testimony from your traffic professional, I don't remember her name, this whole issue with that intersection, okay, was brought up for me, okay? And at first, there was never, ever a truck gonna make a right-hand turn onto 547 heading towards Howell South into Lakewood, okay? We argued, me and her argued a little bit, went back and forth, okay? It was never, she never ever agreed to that. No way, we'll never make a right-hand turn. And then a couple meetings later, she came back and had this whole new deal. We're gonna widen the road for you, move the telephone pole, because you know what? Maybe the trucks will make the right-hand turn, okay? So, you know, I disagree with what you said, that, you know, you're doing this, you know, as a favor to the town or a favor to the residents. That's not true, because you guys have testimony saying that if that's what needs to be done, that's what will be done. Do I have to, you know, go back on the minutes and look at it? You know, your traffic expert said that. So, you know, I disagree with some of your testimony. And I disagree wholeheartedly that this, at the end of the road, doesn't, you know, require maybe some other look at from our zoning board or something. But that's, you know, I'm not an attorney or one of our paid professionals, all right, sir? Yeah, that's all.
Okay, so Mr. Simon, now you wanted to address the most recent letter?
Yeah, thank you, Mr. Cucciaro. And just very briefly, just because it was only submitted 2 days ago and didn't have a chance to provide a written response, but I'd like to briefly respond right now. So there was a letter dated, I believe, October 3rd from council, and they talk about the issue of the applicability of the new inland flood protection rules that are part of regulations promulgated by the New Jersey Department of Environmental Protection. And the argument goes that under section, I think the argument goes that under section 10.5 of the municipal land use law, while there's a provision that states there that any development regulations that are in effect on the date of submission of an application for development shall govern, but that if there is an ordinance that relates to health and public safety that is adopted subsequently, then that ordinance potentially could be applicable to any application after it is being deemed complete. And I believe that council's argument is that the new inland flood protection rules that were adopted, I think around July 13th of 2023, thereabouts, apply to this development, to this application, because it affects health and public safety. That's not correct. So first of all, the new inland flood protection rules are not an ordinance. Section 10.5 only talks about ordinances, and in fact, in the, what is called the Cox book, now the Cox and Drill and Lisa John Basta book.
The Cox and Koenig book.
Yes, and Koenig, of course, Stuart Koenig. It states that Section 10.5 only applies to municipal ordinances. So the flood protection rule cannot be considered as an exception to the time of application rule for health and public safety reasons. End of story. There is no case law to the contrary. There's no statute to the contrary. There's no regulation to the contrary. Furthermore, The inland flood protection rules modified two sections, two regulations. The Flood Hazard Control Act, which is Section 7:13, as well as the Stormwater Management Rules, that's NJAC Section 8. This project does not require a flood hazard permit. So Section 7:13 that is cited by Objectors Council in their letter of October 3rd is completely inapplicable. The correct citation has to do with the stormwater management rules of Section 7.8. And even if I was wrong, which I'm respectfully not, in terms of an interpretation of the time of application rule or statute under Section 10.5 of the Municipal Land Use Law, there is a grandfathering clause in the stormwater management rules that basically says that any application that was, in this case, the freshwater wetlands application for the applicant, which included stormwater review, if deemed technically complete, in this case, prior, which is on April 4th, 2022, and technical review began on April 26, 2022, because it was a complete application submitted to the DEP on or after March of 2021 and prior to July 17th of 2023, the project is subject to the stormwater rules in effect on March 2nd, 2021. So it's actually stated in the amended stormwater rules that the new inland flood hazard rules that came about in mid-July of 2023 do not apply. And in fact, ironically, during the comments that were published with regard to the proposed inland flood protection rules, that a certain member of the public said, hey, you know, when you're considering finalizing these inland flood protection rules, you should utilize what is utilized in Section 10.5 to have exceptions for public health and safety. And the DEP responded to that. And they actually said in response, and this is published in the New Jersey Register, in cases where an applicant has proposed a major development and applied for a freshwater wetlands permit, which triggered a review of stormwater management, the rules in effect at the time of the DEP application govern the department's review of the project. The department cannot retroactively apply newly adopted standards to projects that were submitted prior to the rulemaking in question. So, for that reason as well, that there is no exception to the time of application rule in Section 10.5 of the Municipal Land Use Law. And finally, I believe that there was a comment having to do with our environmental impact report and that it doesn't address alternative plans that could be developed on the site. In response to that, I will tell you, if you look at page 5 of the environmental impact report, it specifically talks about project alternatives, such as a no-build alternative, as well as alternative uses. And as I stated probably in the second sentence before this board at the commencement of this application proceeding, this board is now aware that a solar panel application was submitted for this property to the Board of Adjustment and denied. Notably, you know, the environmental impact report has been submitted for review by the board, and we have not heard anything about the report being insufficient. Furthermore, should the board ultimately find that it's not in compliance for some reason, which we contend that it is, the board has the right under the ordinance to waive portions of a requirement for an environmental impact report that it is a particular section is not needed in order to adequately evaluate the environmental impact of a particular project. That being said, we submit, as I just stated, that we did submit what is required under the ordinance for the environmental impact report. So I just wanted to touch on that because it was raised via the letter of October 3rd.
Counsel, do you
Mayor.
want to make any comments with regard to the most recent letter brief you submitted?
Please. The MLUL statute that was cited governs the authority of the municipality. We're not talking about the DEP's authority over the inland flood protection rule. We're talking about the municipality's authority. The municipality must adopt the inland flood protection rule. They have no choice. If there's not an ordinance now, there will be. The municipalities can't have less protective stormwater protections than the state. The MLUL statute in question permits a municipality, when there's a question of health and safety, to leapfrog the time of application rule in order to be more protective with regard to whatever development is being proposed. I think it's undisputed that flooding is a safety issue. This MLUL statute gives the municipality the authority to consider if it wants to apply the inland flood protection rule. We submit that it should in this case. This property will have an enormous impact on stormwater. I think that's undisputed. It's a huge warehouse. We would like to provide testimony from our expert, Mr. Gall, that the application would look significantly different if the inland flood protection rule were to be applied. And that has meaning. It has meaning to the neighbors around this site. If there's flooding in the future, are we going to question, should we have applied that inland flood protection rule? Why not be overly cautious? Why does the applicant try to avoid being overly cautious to protect its neighbors? I think in this case, the board can step in, the municipality can step in and decide, okay, we want to apply this more protective rule for the safety of everyone around us. And with regard to the environmental impact statement, I have no further comment.
Okay. Mr. Chairman, I just have a question for our board's professionals. So under the time of application rule, an applicant has vested rights in the ordinances as they exist at the time the application is deemed complete, generally speaking. There is an exception for health and human safety. But my question is, has the township's ordinance changed at all for stormwater management since the filing of this application?
No.
No. So there's no ordinance that we would apply in place of the one that exists at the time that this application was filed?
Correct.
So with that said, Mr. Chairman, we can't replace the ordinance with an ordinance that doesn't exist under the time of application rule. With regard to, other arguments that council has made, I don't think we need to opine at all with regard to whether they're going to be what rules they'll be subject to with the NJDEP. That's an outside agency approval. That process will take its course, and they will need to have approvals. But with regard to our local ordinance, the ordinance hasn't changed. There's no new ordinance to replace the current ordinance with. So my recommendation is that the time of application rule is not an issue with regard to the stormwater management regs.
Okay.
Now, there was additional statements in the letter, and I think that applicant's counsel wanted to provide some arguments with regard to additional testimony that the objector wanted to put on tonight.
Well, no, so let me try to summarize where I think we are procedurally with regard to the application. So the last thing that happened was that Mr. Lieberman had the opportunity and asked a few questions of our traffic consultant, Ms. Penke. And then he stated he had no further questions. So what we stated was going to happen next, and what we intend to proceed with tonight, is to provide some rebuttal testimony from our engineer in response to some of the comments made by the objector's expert, Mr. Gall. At that point, counsel would have the right to certainly cross-examine any of that additional testimony or new testimony that we're presenting tonight. Once that is, and obviously board professionals and members of the board, once that is done and that witness concludes testimony and cross-examination by objector's counsel, at that point, I believe what should happen and what was contemplated or is contemplated is that all of our witnesses that have provided testimony in support of this application from the very beginning be made available to the public for questions by members of the public, understanding that Mr. Lieberman's office would be done with all questions because they've already had the opportunity to ask those questions with the exception of any new testimony that's being presented tonight. And then the board would proceed, I believe, presumably with public comment on the application.
Mr. Chair,
Yes.
I think that's an accurate restatement of what happened. However, I don't think that there's any, constitutional harm or any statutory impediment to the board allowing additional cross-examination from counsel for the objectors tonight. And then I think there was an additional witness, counsel, you said you wanted to put up tonight?
Yes, Mr. Chair, I would like to cross-examine the traffic expert again.
Well, I just recommended that be permitted, so.
Then I won't belabor the
Unless you
point.
want to argue with me about that.
I do not.
With the understanding that if any, subject matter was already covered, that there shouldn't be a repeat of
Well,
those questions.
As is the rule for anybody cross-examining, the chair reserves the right to limit anything that is repetitive or irrelevant.
And
But you said there was a new witness?
not a new witness. We have our expert engineer, Mr. Jeff Gall. He already testified, but we'd like to provide supplemental testimony in response to the revisions to the stormwater.
Mr. Chair, I would recommend that purposes of allowing the full hearing where all parties have an opportunity to be heard, that you hear that expert testimony as well.
Yes.
All right, so I
Nobody
think
from the
that's all
board
the
thinks that,
procedural
so.
issues. Either counsel, are there any more procedural issues that we need to go through?
Not that I'm aware of.
Okay,
Mr.
so let's
Sherrill.
So
get
you know what?
started.
Thank you.
Before we get started, we're taking 5 minutes, because we're going to be here for a little while. So we'll take a 5-minute recess, and then we'll just get rocking and rolling.
The board will now take a 5-minute recess. They'll be back at 5 after 8.
Mr. Chairman's very friendly.
The planning board will now reconvene.
Thank you, ladies and gentlemen of the board, board professionals. At this point, I'd like to recall for some rebuttal testimony, Tung To Lam, please, our engineer.
Okay, I remind you that you remain under oath. If you could just state and spell your name for the record again.
First name is Tung To, T-U-N-G-T-O, last name Lam, L-A-M.
Okay, go ahead.
You can pull that mic now closer to you if you
Yeah,
want.
just,
Perfect. Thank you.
So Tung To, as part of your work on this application, you recently submitted or authored a letter to this board dated September 22nd, 2023. Is that correct?
correct.
And that letter has been marked as A52 for identification, correct? Yes, correct. And that letter provides a summary with regard to some stormwater rebuttal testimony with reference to certain exhibits that have been previously submitted to the board, correct? Correct. So I'm going to ask you to summarize the letter of September 22nd, 2023, going through each enumerated item and just explain a little bit what each refers to.
Will do. Starting with the September 22nd letter, also known as Exhibit A52, Point number 1 is about the topsoil. There was a question if we're keeping it on site. This is an affirmative. We are keeping the topsoil on site and we're not exporting it off site. And that is exhibit A53 for the topsoil exhibit that we prepare.
So when A53, proposed topsoil exhibit prepared by Bowler Engineering, dated June 12, 2023, that's what 1A is referring to.
Correct.
Please proceed. Go to number 2.
Point number 2 is the summary on the difference between point of analysis point of analysis 1 and point of analysis 2. We have in a chart form provided that summary for the 2-year storm, 10-year storm, 25-year storm, and 100-year storm. So the information has been provided as the same as the table in the stormwater report, but we just summarize it in a table format for everyone's purpose.
Moving on to number 3.
Number 3, there was a question about the French drain detail, whether it was infiltration or not. We have added a impermeable liner on the free side of the French drain and keeping the top as filter fabric as previously designed to eliminate any alleged groundwater comments from the objector. So on the free sides of the French drain, it will be an impermeable liner, and on the top will still remain as the filter fabric.
And does 3A of your September 22nd letter refer to a particular exhibit?
Sorry, that is Exhibit A47, which is up on the screen right now.
So that's entitled French Drain Exhibit, consisting of one sheet prepared by Bowler Engineering, dated August 9th of 2023?
Correct.
Please proceed through the letter.
Point number 4 is about if we model the existing impoundment or not, and in coordination with your board professional, CME, and their review of our design, we did in fact model the impoundment, 2 of them for existing E1 and E2, and they do have an impact. And for E1, because we modeled the impoundment, there's a difference between 15 to 19%, and that was provided in the stormwater report that has been reviewed by your board professional. And similar under E2, it ranges from 10 to 32% in difference of stormwater runoff. And we did, in fact, include those impoundment in our models already.
Moving on to number 5.
Number 5, we'd like to bring up Exhibit A48, which is the anti-seep collars exhibit prepared by Boulder, dated June 12, 2023.
So why don't you explain what the purpose of this exhibit submission is?
There's a question about the stormwater trenching and the groundwater elevation, and the anti-seep collar is to address that, and we have located the location on the plans on which pipe run will have that feature. And that is shown on Exhibit A48.
Okay, moving on to number 6.
Moving on to point number 6 is about the pipe joints. What type of pipe joints are we using for this project, if they're water type, if they're soil type? So if we refer to Exhibit A46, titled Pipe Joints Exhibit, prepared by Bowler, dated June 12, 2023. Once again, we went through and looked at the geotech information and our stormwater design, and we highlighted the pipe runs if they are soil type or if they are water type joints.
Is that in reference to A46?
Yes, the pipe joints is shown on A46.
That's dated June 12th of 2023.
Correct. Point number 7 we'll skip in order to give back the precious time to the board members. It was about the grandfathering of the stormwater regs that has been discussed already.
That was part of the discussion I had with council just a few minutes ago, correct?
Yes. Skip skipping ahead to point number 8. It was about where soil replacement was required for the various basin or not. In summary, Basin 1, Basin 2, Basin 3, and Basin 4 soil replacement are proposed, and that has been part of the application already. Basin number 5, we're not proposing any soil replacement, and that's consistent with the plans that has been previously submitted.
And finally, number 9.
Our last point, point number 9, there was a comment about the 25 trees that are proposed on the side of the basins. We reviewed the landscape plan, and we think that the tree and the shrubs, the landscaping will actually help keeping the soil in place, and we believe that is a good practice. And the berm, the side slope that the objector is talking about is only 2 to 3 feet high. And trees are proposed on the interior side of the slope. There's no safety or is there stability of their embankment being an issue. And that concludes my testimony.
Okay, we have nothing further from this witness?
Okay, do you have any other witnesses?
I do not, other than making our witnesses available for cross-examination.
Okay, so
Discussed.
your affirmative case is concluded.
For now, subject to anything that anyone may state.
Okay, counsel, do you want to cross-examine?
Yes, please. Good evening, Mr. Lamb. My name is Brittany DeBoard. I have a few questions for you. First is with regard to the French drain, and can I ask whoever's controlling the screens to, perfect. Mr. Lamb, the change you made to the French drain proposed for this site, that involves an impermeable layer, is that correct?
Yes.
And that impermeable layer, it wraps around the drain on 3 sides, and then there's still filter fabric at the top of the drain. Is that true?
Yes.
Did you make this change in response to my experts' concerns about the seasonal high groundwater table?
We made this change because we thought it was a silly comment, but we don't want to argue it, so we did it.
I'm sorry, can you just repeat that?
We made the change based on comments from the objector. We didn't feel like it was necessary to argue the point, so we simply added the impermeable liner on 3 sides to address that issue.
Okay, thank you.
Well, the concern was that the seasonal high water table was above the French drain. Is that your understanding of the concern?
Wait. Objection, concern relating to what? What are you?
Well,
Mr. Simon, we can't hear you.
I'm sorry, Ron. I just posed an objection because I didn't understand the context within which the question was asked. So if you can repeat the question with the foundation, thank you.
Mr. Lamb, you indicated that you made this change in response to our expert's testimony about the seasonal high groundwater table. And my question to you is, was your understanding of his testimony, of his concern about the water table, that it was above the French drain? In other words, in elevation, the groundwater was above the French drain.
Do you understand the question?
No.
Help me understand what your understanding was of my expert's testimony about the seasonal high groundwater table and why you made this change.
We made.
Wait. I'm gonna object because you can't ask him what's his understanding about testimony. If you have a question, ask him the question.
Mr.
You have
Chair.
an answer.
The rules of evidence are not strictly applicable, but in this instance, the answer was there was an objection. They were comfortable with the design as it was proposed, but in order to eliminate the objection, they modified the plan. So, I mean, I think that was his answer.
Okay. Fine. Let me ask you another question. How do you believe the impermeable layer will alleviate concerns about the height of the seasonal high groundwater table?
Brittany, I'm sorry. What are you referring to when you're asking the question?
I am referring to the change in his design.
What in particular is
There
it
is
an
a
exhibit?
single change in the design, which was the addition of the impermeable liner.
Right, which, I'm not trying to be argumentative.
No,
Just
no,
tell me
no.
what exhibit are you referring to?
This very exhibit that we're looking at.
Okay, which exhibit is that?
47.
47, thank you. You can repeat the question?
So my question to you is, do you believe that this impermeable liner that you added, this change to your design, will alleviate the concern about the seasonal high groundwater table being so high and potentially above the French drain?
Objection in that there's a concern, but if you understand the question, you can answer the question.
We didn't have a concern, like I said, we added a liner to avoid arguments.
So then, just more in tune with the question, if you made the change based upon the argument that was made, then you believe that it addressed the argument.
Yes.
So the testimony is that they believe, or this witness believes that the new design addressed the argument that was raised and the concerns associated with it.
Mr. Lem, is the seasonal high water table above the elevation of this French drain?
Above which elevation?
The relative elevation. Is the seasonal high groundwater table above the French drain? Is it above relative to the French drain? The pipe, excuse me.
I don't think that's a difficult question. I mean, you're familiar with the high water table, correct?
I'm looking
Okay.
for the exact number. Yes, there's some area of the pipe length where the seasonal high water is above the invert of the pipe.
So do you believe there is a likelihood that this pipe will redirect groundwater in the location of the pipe towards the infiltration basins?
No.
Why not?
My answer is no.
Well, she asked, that's a conclusory answer. It has to be based upon something.
The slope of the pipe, we added an impermeable liner around it. We got data around the site. We've done multiple rounds of geotech on this site. We have actual information about this site that we gather, and that's what my information is based on.
The detail that we're looking at right now, the French drain detail, the caption to the right of the pipe says, as determined in field to capture subsurface seepage. Would you agree that subsurface seepage is groundwater?
No,
What is subsurface seepage?
that water is coming in on the top of the pipe where we designed it for.
Okay, but that's water that enters.
What is the difference between subsurface seepage and groundwater? Like, is there a different definition for both of those terms?
I believe the objector is referring to the groundwater, and our design intent is to capture the surface runoff, which is why we left the top layer as a filter fabric.
Okay.
Okay, counsel?
What I'm trying to understand, and I won't belabor the point for the interest of time, but why is it that you believe that the seasonal high water table is over the filter fabric, which is, the filter fabric is meant to take in the water seepage, is that right?
Yes.
So if the seasonal high groundwater table is above that filter fabric, how in the world does that water not get redirected by the French drain?
That was not my testimony. That's your testimony.
She's
No,
not
I'm
offering
asking
testimony.
you.
I never said the seasonal high groundwater was above the filter fabric. Those were not my words.
Well, perhaps you can clarify what your testimony was.
I said we propose a impermeable liner on 3 sides because the objector had a concern that the seasonal high groundwater would enter this French drain.
Okay, so is it your testimony that the seasonal high water table does not exceed the elevation of the filter fabric?
Correct.
And based on what? What is that testimony based on? Have you done any calculations or modeling?
We have gone out there, gathered test pits, recorded data throughout the sites, and based on what we have and what's shown in the plans, that's what we designed it for.
Is there any specific data that we can look at that suggests that the seasonal high water table will never exceed the filter fabric in elevation?
The information is already submitted in the stormwater report.
Okay, but you can't recall sitting here?
No.
Is there ever a scenario where the water table might exceed the filter fabric? Say, heavy storms, unseasonably high water table, any scenario?
Not likely.
Why not?
We gathered the information based on NJDP requirements, and based on information that we have, it's not likely.
And in practice, you believe that this French drain will never take on groundwater?
It has been designed not to.
But that was not my question. In practice, you don't believe this pipe will ever take on groundwater?
It's not what we designed it for.
That's the answer, counsel.
I'm happy, thank you.
Yeah.
All right, let's move on to the anti-seep collars. This is A48. Oh, someone's fast, thank you. All right, Mr. Lamb, you added the anti-seep collars, and this is my understanding, correct me if I'm wrong, to address the concern that the subterranean piping you've proposed will act as a conduit for groundwater flow. Is that right?
Yes.
And you indicate in your rebuttal letter that the anti-seep collars were proposed in order to retard groundwater from flowing within those conduits. Is that right?
Within the stormwater trench, yes.
So I think the question is, do you believe that the anti-seep collars will actually stop the groundwater flow along the conduit or simply slow it down?
Stop.
And based on, I'm reading your letter and it doesn't suggest that. It says it would retard groundwater flow. But you're telling me that you actually in fact believe that the collars will stop groundwater flow completely?
Yes.
Have you seen this in action? Have you utilized anti-seep collars before for the purpose of stopping groundwater flow along a conduit?
Not exactly.
Have you ever used this as a solution for this problem?
Objection, what do you mean by problem?
Oh, sorry, excuse me. Have you, Mr. Lamb, in the course of your work as an engineer, have you ever utilized before anti-seep collars to address concerns about groundwater flow along subterranean conduits?
Yes.
Can you give some examples of projects where you've done that?
Similar case for a sewer pipe.
Can you be more specific? What town?
If you recall.
I do not recall.
Okay. And do you know if in fact those anti-seep collars were effective in completely stopping groundwater flow?
That's what they're designed for.
No, but in this example that you're giving me about a sewer pipe, have you seen the anti-seep collars in action? Do they actually work?
Yes.
Okay. And based on what?
Wait. Yes, you've seen them in action and they work.
Correct.
And is that based on follow-up visits, reports from the client?
Yes.
The watertight pipe joints, did you also propose watertight pipe joints to address the objector's concerns?
We did.
Okay. With regard to the trees proposed along the embankment, would you say it's common practice to put woody vegetation along embankments?
It is.
Have you proposed woody vegetation and embankments in other projects?
Yes.
Can you give me an example of those other projects?
Let's just say I can't think of one project where I haven't put it, vegetation on the side slope of a basin.
Does that include embankments over 5 feet that are regulated as dams?
Yes.
Are you aware that it's best practice not to implement woody vegetation on dam embankments because it causes structural insecurity?
Wait, when you say best practice, what are you referring to?
Well, actually, if you may, we have a reference that my expert intends to rely on, but I can.
All right, well, maybe you can present whatever you want to present.
Is
with your
there
witness.
a citation to like an administrative code provision or something like that?
Well, this is a guidance document from the Association of State Dam Safety.
All right, so I
Officials.
think what we'll do is you can, obviously the answer to the question is that the engineer believes he's followed all necessary requirements. You will have an opportunity through your witness to disprove that.
We'll do, thank you. Mr. Lamb, I just have one more line of questioning for you about the interaction between the French drain along the southerly portion of the property and the infiltration basin adjacent to it. Is it possible to zoom in to the southerly, zoom down?
Exhibit A46.
Yes, thank you. Just a little bit more to the south. We're going, yeah. And centered. Down a little bit more. Sorry, down all the way. Yep, perfect, thank you. Mr. Lamb, have you taken into account any potential interactions between the infiltration basin along the south of the property, right above on the top of the embankment, with the French drain at the bottom of the embankment?
What exactly do you mean?
Well, okay. So the infiltration basin, it's designed to recharge groundwater. Is that right?
Yes.
And its function is it will take on stormwater runoff, filter it, and the groundwater will be distributed underneath this infiltration basin. Is that right?
Okay.
Well, is that?
Yes.
That's okay. And the infiltration basin is higher in elevation than the French drain. Is that true?
It is.
So, are you concerned at all that the groundwater that's getting recharged by the infiltration basin will just enter the French drain and get drained out into the drainage basins to the west of the property? East, excuse me.
No.
And why not?
We design it in accordance to NJDP requirements, including an analysis for mounting analysis and things of that nature, and we have no concerns with our design.
Well, have you done any studies or modeling that takes into account the interaction between these two features?
Two features being which? The basin and the French drain?
Right.
We reviewed a mounting analysis and we have no concerns.
Well, I'm not talking, I will ask about the mounding analysis, but my question is with regard specifically to the groundwater recharging into soil that's above the French drain, higher in elevation than the French drain.
My answer remains the same.
So you've done no modeling or calculations to
I
address that?
said I've done my analysis in accordance to DEP requirements and I have no concerns.
Okay. And in terms of the mounding analysis that you prepared for the infiltration basin, that mounding analysis is the function of the water table, sorry, I'm trying to figure out a way to put this. The mounding is a function of the water table being artificially higher than the surrounding water table as a result of groundwater recharge. Is that right?
Yes.
When you calculated the mounding, that artificial elevation, does that mounding enter the French drain area?
No.
And is there any document or calculations that you can point to that evidences that statement?
My calculations include on my stormwater report that was previously submitted to the board already.
Okay. Does the mounding, your mounding analysis in your stormwater report show the location of the French drain?
No, because it's just a spreadsheet. You have to actually look at the plans and compare the two documents.
And I have one final question. Your attorney may object, but with respect to the intersection improvement at Victory Road and Route 547, you haven't conducted any stormwater analysis with respect to that site, have you?
Objection. Your clairvoyance is impressive.
Thank you. I do think it's relevant.
So just restate the question.
The question was just confirming that Mr. Lamb didn't do a stormwater analysis with respect to the off-site improvement.
Objection. It's irrelevant, but if you want to answer the question.
Mr. Chair, rules of evidence not strictly applicable. It's part of an overall plan that was submitted. I think the witness can answer.
The answer is no.
Okay, you have any more questions, counsel?
I'm just making sure. I don't have any further questions. Thank you very much, Mr. Lamb.
Okay, and I think you said you wanted to ask some additional questions to the applicant's traffic engineer?
I do.
I'm sorry, Ron. Just, is she going to do that now, or? Does
Yeah,
she
we'll
want
do
to-
that now.
Okay.
We'll get all of the objector's questions done. So if we could just produce the traffic engineer. Okay, I just remind you that you remain under oath. If you could just state and spell your name for the record again.
Yes, of course. Carrie Penke, Kerry Phenke.
Okay, counsel, go ahead.
Thank you. Good evening, Ms. Pankey. Would someone blow up A45? Oh, I'm looking for the concept plan. I think that's A45. Oh, A43, maybe?
45.
Perfect, that's it. Thank you. Ms. Pankey, the applicant, representative of the applicant, indicated that strike that. Ms. Pankey, would you confirm that the accessway is necessary for tractor trailers to be able to take right turns onto Route 547?
Wait, first of all, when you say you're referring to Exhibit A45, and which accessway are you referring to?
The proposed accessway.
Okay.
Do you know what I'm talking?
The channelized right turn?
Correct.
Yeah, the easement. It's necessary for buses to make the right turn movement without encroaching over the center line.
And as well as tractor trailers?
Yes, those are larger than buses.
Okay. And to your knowledge, is there a bus route on Victory Road?
We did count school buses making that right turn, correct?
School buses? Okay. And in order to make the right turn at this time, do large vehicles such as buses and tractor trailers have to make illegal turns, for lack of a better term?
Wait, a couple of objections. First of all, what do you mean by at this time?
In current conditions, I think.
And what do you mean currently?
Yeah.
Under
I would-
current conditions of the intersection,
Right.
school buses will encroach on the center line of both Victory Road and Lakewood Farmingdale Road to be able to make that right turn.
Understand. And how many school buses a day?
If you let me check, I do have the count.
Oh, okay.
I just want to confirm. I think I know it, but I just want to be able to give it to you. So the total buses we counted making that right turn was 2 throughout our count periods. We counted from 6 a.m. to 10 a.m. and 3 p.m. to 6 p.m.
And did you count tractor trailers as well?
We counted articulated and single-unit trucks, so that includes a wide range of trucks, and only one had made the right turn.
Do you know if any of those trucks came from businesses along Victory Road?
I do not know their origin.
With regard to the warehouse, the subject development, the warehouse, would you agree that this access-way is necessary for the warehouse to conduct operations as planned?
I do not.
And help me understand why.
I do not because the tractor trailers, the largest size WB67s, in my professional opinion, are going to be oriented to and from the regional roadway network, and it would be quite infrequent for them to make the right turn there. And yes, I said it would be quite infrequent that they would do it, and per DOT code, actually, because of the infrequency that we would anticipate of that size vehicle going, it does allow for encroachments over center lines for design purposes.
Okay. So as it exists right now, the only way that trucks would be able to get to and from the warehouse are from the the portion of 547 that's to the north of Victory Road, is that right?
That's the routes that we would expect for this land use, for the trucks to be oriented to and from.
And Victory Road itself, do you know the weight limit for that road?
I don't believe there is a posted weight limit, not that I've observed.
Are you aware, are there any permits required for trucks to access that road?
Not that I'm aware.
And do you know if the road is on the DOT map of permitted trucking roadways?
Which road? Victory Road?
Yes, Victory Road.
I don't have the map in front of me, so I can't answer that specifically, but it's not a restricted truck route.
Okay, that's a good answer. Do you anticipate that the addition of this accessway will increase truck traffic in this area?
What access way are you referring to?
The same turn, what did you call it? The accessway,
The channelized right turn, the easement area.
correct. Do you anticipate that the channelized right turn will increase truck traffic to this area?
I don't believe so, no. It will benefit the current vehicles that use it. The proposed warehouse, we anticipate the trucks are going to and from the regional network, so, I don't think people, my profession doesn't change. Trucks aren't going to be going right there. It'd be very infrequent for trucks of that size to make that turn.
Other than the addition of the trucks that will be accessing the warehouse, right?
Not making the right turn, the larger vehicles going to and from the regional network, the interstate.
I have no further questions. Thank you.
Thank you.
Thank you.
Okay, counsel, were there any other witnesses that you wanted to ask additional questions to?
No, sir. I would only like
Okay.
to present my witness.
Now, you said that you have a witness that you wanted to have provide additional testimony tonight?
I do, and that's Jeff Gall, professional
Okay, Mr.
engineer.
Gold, you were previously sworn, correct?
Yes,
I remind you, you remain under oath. If you could just state and spell your name for the record?
sure. My name's Jeffrey, it's Geoffrey, middle initial M, last name Gall, Goll.
Okay, go ahead, counsel.
You don't need me to qualify him, do you?
No, he's already been qualified.
Good evening, Mr. Gall. Mr. Gall, have you reviewed the proposed changes to the stormwater plans that were submitted by the applicant? And specifically, I'm referring to the impermeable layer around the French drain and the anti-seep collars.
Yes.
And would you provide an explanation as to whether you believe these changes will allow the stormwater system to function as intended?
So the applicant's engineer initially tonight stated that the liner was installed because my concern that this French drain, as they call it, would infiltrate ground, water into the ground below it. And in fact, it was the opposite of what I was concerned about. Number one, and I did it's my own hand sketches that I did, but when you look at the seasonal high groundwater table compared to the invert of the French drain has an invert. It's, in other words, the bottom of that. Could you pull the detail up of that? Thank you. So the bottom, at the bottom of the 10-inch diameter perforated pipe it's at elevation 73. And based on reviewing test pits in the area, the seasonal high water table is at 74.8, which is about 1.8 feet above the bottom of the invert. So the question then became, okay, well, the detail doesn't provide a specific depth or height of where that impermeable liner is going to come up. But what's contrary to what is that liner would do if it was high enough to block the seasonal high groundwater is the label on the right that says, as determined, the depth, it shows the depth of what this trench will be, as determined in field to capture subsurface seepage. So it's either surface water seepage, water flowing over the ground, and if it's underground, it's groundwater. And so what the intent of this detail is, the original intent of this detail was to capture water, number one, from ponding, because this was a naturally low area in the back corner of this property, and because they're filling right up to the property boundary, they knew that if they were to not put a drain here, surface water would back up, and it would pond and extend onto the neighbor's property because they're losing that localized storage area. Now, they are capturing some of that in the parking lot, they're capturing some of that on the slope, and they put this in to capture that surface water that would be going into the drain. And I think the engineer had testified to that. It's really to capture surface water. But I think the other concern that they have is that there would be potentially groundwater that may come up and then go into the they should be concerned about water going into this trench with the stone, and then being basically negating any kind of infiltration volume for volume that this groundwater now the recharge systems provide. Another thing I did is
Wait, and the concern is based on the level of the seasonal high water
correct,
table,
the seasonal
right?
high being 1.8 feet above the invert of this basin. The applicant's engineer stating that they did it just to simply satisfy our comment is not, I don't believe, is true. And that would have to be further defined on that detail to figure out how high that impermeable liner should go to isolate the seasonal high groundwater from the trench.
But there's another complication here, and if you can pull up the anti-seep collar drawing and then zoom in on that basin number 5 at the southern end. And pan down. Thank you. Right, a little over to the left. Oh, no, down, down, down. It's like somebody scratching my back. I need you to move over a little left. There you go. So if you look at where the horizontal lines under the park.
Can I make a suggestion? Just reference the exhibit.
Oh, okay, thank you.
Public knows
What exhibit is this?
A48.
All right, thank you. Thank you.
You're welcome.
This is Exhibit A48. And what I'm pointing to is, it's called Basin Number 5. It's a subsurface infiltration basin underneath the parking lot. And it shows that in relation to the French drain, which is that darker line, well, for lack of a better word, to the south and below it, at the toe of the slope. And if you draw a simple sketch, you can see that obviously the invert of that French drain is 4 feet lower than the invert of the infiltrative surface of that basin. Now, when water goes into an infiltration basin, it doesn't simply go vertically down. It goes down as well as going sideways. So as this basin were to fill up with water, water not only seeps out the side, it seeps out the bottom, it seeps out the sides. And so you're going to get a lateral movement of water. The mounding that they talked about is where the water is traveling down at a certain rate, where as soon as the groundwater cannot, it's sort of like a traffic jam. There's a certain amount of water going down, but only a certain capacity of the groundwater system to absorb it. So water artificially rises up as it queues, waiting to be absorbed by the ground. And so you get this, what they call a mound. The groundwater goes like this underneath the basin. The center line of that detention basin along the long side is 35 feet, is 30 feet to the center line of the infiltration trench. So that's 30 feet. When you look at the mounding analysis for Basin 5, the outer extent of that mound from the center line of that infiltration basin, where it stops elevating above normal conditions, is 35 feet. In other words, that mound extends to the property line a little bit. It probably goes right to, if not just past the property line, but gets intercepted by that French drain. So depending on where you put that impervious liner, may impact how that water then travels into the water gets from that infiltration basin into that drain. Why is that important? Because that groundwater is supposed to literally go into the ground. The basin that it goes to, which I believe is basin number 2 on the right, if you go all the way to the right, you see where the one on the bottom right, that is basin, I believe that's basin number, let's see, where's the label? No, I'm sorry, that's basin number 4. So basin number 4, no, it's on the bottom, on the right. That was designed to capture a certain amount of surface water from the project site, but it was not designed to capture water from one infiltration basin, get intercepted by the French drain, and then be discharged to that basin number 4. What that could do is, during the winter months especially, it could add additional hydraulic loading to that basin as the water gets intercepted. That basin then holds potentially, the applicant's engineer still has to prove this, will hold that water for longer than 72 hours, which is the maximum amount of time a basin's allowed to have visible water at the surface. And so it's going to overload the basin potentially and have an impact on how that basin functions. So, those are a couple of very large concerns I have about that French drain they installed on that side of the property.
And Mr. Gall, just to clarify, and based on your understanding of this design, is it your opinion that at some point during the year, the groundwater table level will be higher than the French drain by virtue of the table naturally and mounding?
Yes.
And And do you believe, based on scientific certainty, that the French drain will essentially drain groundwater from one area of this site to the basin in the other portion of the site?
That's correct.
And is it your understanding that this basin was not designed to receive excess water beyond stormwater runoff?
Besides surface runoff, correct.
Besides surface runoff. And aside from the basin not being able to drain in compliance with the 72 hours in the BMP manual, what are the other adverse impacts of this basin being filled with excess water?
Well, if water stays in too long, and let's say we get into the springtime and the growing season, and it, warms up, you can get algae, you can get surface scums that'll actually, because if the water sits there for a long period of time, we've seen this in basins that fail, it's going to promote algae growth and organics, and then it could clog up and require more maintenance to the basin. The other thing, obviously, if water's sitting there for a very long period of time, it can end up being a mosquito breeding issue. And these basins are sand, they're covered with basically sand, there's not really a habitat associated with them, and so it'll end up creating an optimal area for mosquito breeding.
Thank you.
So, I mean, I can go on to other.
Yes.
All right. So, can we pull up the topsoil detail, which is A53. I'm going to be frank, this is the first time I've seen this detail. On the website, when I looked at the listing of exhibits, it stops at A52. I'm not saying it wasn't submitted, I'm just saying that we didn't have a chance to observe it. But I was able to intuitively understand what they're going to be doing. So the prior plans that I had critiqued last time I was here, I had explained that I forgot the exact amount. Naturally, there's like 12 or 15 inches on average of topsoil on the site. And the plans, there were two different locations in the plans, that one called for 4 inches of topsoil to be placed back and one called 6 inches of topsoil. I'm assuming this was then prepared in response to that comment that I had made because of the concern for exportation of topsoil. So when you'll notice though, I'm assuming that they're going to be spreading this topsoil. I made the assumption that at this 29 inches of topsoil they're going to be placing around the site will be done relatively evenly. That's all I could make the assumption about. And a couple of things to understand. So, for example, how that will impact, well, topsoil itself is an organic material, and that's why it's good for plants. It has organics in it. Biodegradable materials, and then plants can uptake the nutrients, and it's a natural soil surface. But it also can degrade over time as well. So, for example, that's why you're not allowed to put topsoil underneath the foundation of a building, for example, or a roadway, because it has detrimental effects. Once it starts to decompose the organics, you can get settlement. So, as just a for instance, a couple of examples. So, you'll see those small little islands there. A lot of those islands, and adjacent to the roadway, the access roads, you're going to have a 6-inch high curb. When you look at the detail for the curb on the plans, which I believe is on sheet, on sheet C901, detail number 5, it's called concrete curb, a 6-inch reveal. I'm not sure of the exhibit. You don't have to go to it at this point, unless you want to see the detail. I can describe it. Below the lawn side, so you've got the curb, right, and it drops 6 inches, and you got the asphalt. On the landscaping side, it's 6 inches higher than the road, or the asphalt, or the walkway, or you name it. And then it goes down 6 inches. So the bottom of the concrete footing for these curbs is 18 inches. But right next to it, they're going to put 29 inches of topsoil. So now you're going to have 11 inches of organic topsoil, not underneath the footing, but right next to the footing. And then in other areas where it's either next to pavement or sidewalks, you're now going to have a pretty thick layer of topsoil next to it. So that's a concern in terms of the long-term stability of the sidewalk, or the curbs, for example, and the roadway edges that might be affected if those curbs were then to settle because now the volume goes down as the soil decomposes, and you may get soil that shifts from underneath the curb. So, is that the end of the world? I don't know. I just think it's more of a quality issue in terms of the construction, and that's something that's going to be, that I just wanted to bring to the board's attention.
Mr. Gall, do you want to speak to your understanding of the efficacy of anti-seep collars?
Yes. So the key term that I did notice in the anti-seep collars was, and it's a correct statement, it says, in order to retard the groundwater from flowing within the stormwater pipe trench, anti-seep collars will be installed. Anti-seep collars do not stop flow. Anti-seep collars were originally developed, they used to put them in embankment dams, so like stormwater basins. In some stormwater basins, they still use them, although dam safety, New Jersey's dam safety, and actually the Association of State Dam Safety Officials doesn't recommend the use of them anymore. This is more of an aside, because water still goes along them, and it carries soil with it. Now for dams, they request that you put in what are called sand diaphragms. It captures the water as it seeps out. Doesn't stop the leaking, but it keeps the soil from being dragged out. Soil being dragged along the stormwater pipe is not the concern. The concern is that these anti-seep collars, the way they function is essentially they don't eliminate seepage along the pipe. They create an effectively longer length. So as an example, if you have a pipe that is 200 feet in length, and they put anti-seep collars that essentially, because now it has to, instead of going along the pipe, it zigzags along the anti-seep collar. It doesn't just hit the anti-seep collar and stop. It's gonna go to, the path of least resistance. So if there's a discharge at the end of this, for example, at a manhole at the end, the water will eventually travel. So it'll slow it down, but it's not gonna stop it. So you will still get a net export of groundwater when seasonal high water rises above the stormwater pipes. The next I just wanted to point that out. It's not going to stop it. It's just going to slow it down. So it still will have likely a net effect on seasonal high groundwater. The pipe joints, I'm glad also to see that they put watertight joints in there, because the watertight joints will eliminate water from getting into the pipes, from joints, because I did bring up the last time, I'm glad that they listened to that, is you provide watertight joints, because that's even a shorter distance for water to get into the pipe and then off the site. The only issue I have with that is they probably should check their buoyancy calculations, because now if it's watertight and you've got all this water around it, it's like a boat. It has displacement. So normally, if you have an open void, like a pipe or a tank or an underground tank, it's called, you don't want it to float out of the ground. And I'm not saying this one's going to float out of the ground, but it could still shift. And so the applicant should provide buoyancy calculations to prove that these pipes aren't going to lift out of the ground or lift up and do that. So that's one of the issues. But regardless, there's going to be less water leaving the site. That's something I can definitely agree with, but it's not going to stop the water leaving from the site. It's still going to go around these anti-seep collars because it's below the seasonal high water table.
In other words, it remains your opinion that the stormwater system won't function as intended?
The stormwater pipes will basically negate some of the recharge benefits that you might get from the basins, the infiltration basins.
Okay. And then why don't we address the vegetation on the embankment?
Sure, and then we are jumping around a little bit, but I think this is an important point. I 110% disagree with the applicant's engineer that putting a tree on an embankment that is designed, I don't care if it's 1 foot or 20 feet, to hold back water. It is not a good idea to put woody vegetation on an embankment of a dam, whether it's inside the embankment or on the outside or on top of it. As a matter of fact, I work on everything from small stormwater designs to working on levees, earthen levees to the U.S. Army Corps of Engineers. And I have never heard that putting a tree on an embankment is a good idea. 2 reasons. One is more important than the other in this situation because it's not a big dam. These aren't big. And by the way, they're still dams. They're not regulated dams, but these are small dams. They're not over 5 feet where the New Jersey DEP would regulate them. but they're still designed to hold back water and function. So one of the concerns would be a tree gets older, it falls over, the root ball rips up the embankment and threatens the integrity of the system. Now, obviously, if a tree fell down, you could go in there and repair it and take care of it and fix it relatively quickly. But the other problem is that the tree roots themselves create conduits through the embankments. And so trees are going to both chase where the water is and where it's looking for the water. So if you put a tree on an embankment, on the inside of an embankment, it's going to start spreading its roots, both into the basin, but underneath the embankment as well. And so one of the things that I've just as an aside, I mean, I could have brought in the levee standards and inspection standards where you have to stay 11 feet from the edge of the toe of either side of a levee, but that may have been a bit of overkill for this. But the Association of State Dam Safety Officials on their website has trees and brush, and I can provide this to the board if they want to see it. It's or I could just read it into the record. It's up to you.
Counsel, it's up to you. What do you want to do?
You can read it into the record.
Okay. So this is from the Association of State Dam Safety Officials. I accessed this today. It's called Trees and Brush. There is a website for it. You go to damsafety.org, and it's under the dam owners tabs for them to when they're doing inspections. And it says about trees and brush, or trees and brush hazards. Trees and brush should, and it emphasizes in bold, not be permitted on earth and embankment surfaces or in vegetated earth spillways. Extensive root systems can provide seepage paths for water. Trees that blow down or fall over can leave large holes in the embankment surface that will weaken the embankment and can lead to increased erosion, as is the case in the failed earth embankment shown in this photo, and they show a photo of an embankment that failed. Brush obscures the surface, limiting visual inspections, providing a haven for burrowing animals, and inhibiting the growth of grass and vegetation. So, and then it goes on to trees and brush should not be also allowed next to concrete walls and structures as well. So this is a national authority on embankments and dams, and they should not be being used on embankments of any kind.
Have you made any other conclusions with regard to the changes to the stormwater design?
Yes, there's a few other items. The topsoil, the drain, watertight joints. So, so the final thing is, it was item 8. They do talk about using soil replacement. I guess they recognize that there are certain soil horizons underneath where these proposed basins are going to be, and they're proposing to remove that soil and replace it with a more permeable soil because of the concern that it's not going to infiltrate at the rate they would like, or the rate that would comply, and they're trying to comply with the rules. And that's basins number 1 through basin number 4. That's the underground basin on the top left, or the western side of the property. That's an underground basin, and then the 3 basins on the right, surface basins on the right side. And so there is a concern in the BMP manual, and this wasn't clear, and I'm assuming because they are I'm not sure if they're doing a wholesale replacement or not, but in the BMP manual, under Chapter 12, perch water table requirements, it states, if the hydraulically restrictive horizon does not extend beyond the footprint of the bottom of the basin, in parentheses for me, the hydraulically restrictive horizon may be excavated and replaced with sand. The reason they do that and they put that limitation is, I can dig down and I can replace the soil to try to connect to the groundwater, but if there's a limiting horizon around it, you've just created a tub. Water that rides along that more restrictive horizon outside the basin is going to go into the basin and then into the subsurface. It may sound like a good thing, but it's not, because now you're adding more of a hydraulic load to the system. And you're asking the subsurface in that location now to take water from the perched areas around the basin and go into it. Again, that is something that the applicant has not proven. The idea behind the soil replacement is for like spot replacements where you find, soil it's heterogeneous. It's not always the same all over. You find a spot, or a small area, and you want to remove that limiting horizon and replace it with sand. The other issue that I have is that the mounding analysis was performed using the existing conditions. And this is also going to sound a little bit counterintuitive. When you replace soil with a higher permeability soil, the mound that we talked about earlier, where that mound, it actually rises up further and faster. The reason being is because it's so permeable at the top, once it gets down to the groundwater, the water kind of rushes down relatively quickly compared to what the old soil would have permitted, and that mound can pop up. So they really need to do a mounding analysis on those 4 basins using a soil replace system with the K class or the permeability class that these basins are required, that they're required to put in to make these basins work. So that's my testimony.
Thank you. Thank you for permitting us to add additional testimony.
Just one question. In all of your testimony, where does the applicant not satisfy any of the stormwater management regulations? Can you pinpoint for the board where the stormwater management plan does not satisfy the ordinance requirements?
Again, the issue with, and by the way, some of the items I pointed out there's the regulations and then there's the engineering design that goes with it. So I just wanted to, like the trees. There's nothing necessarily in the regulations that say stormwater regulations, you can't put trees there. But as an engineering judgment, you have to make sure that you're doing what all the authorities
Well,
say.
but my question is, in your testimony, if you can help parse out where it is that you have found violations or non-compliance with our stormwater management ordinance, I think that would be helpful for the board.
So again, the interception of groundwater is negating the infiltration benefits of the recharge basins. So the recharge volumes that they're required, they have to look at what's called the recharge deficit. You have this area of the site, as I understand, is second growth forest and shrubs and brush, and that had it was all pervious, right? And when you put all that impervious down, the warehouse and the parking lots and everything else, it creates what's called a groundwater recharge deficit. That's in the rules. And in order to satisfy that, you figure out what the deficit is. So you get a certain amount of groundwater recharge now, you're going to lose that recharge, and then you have to build these basins to make up for it and get that volume into the ground. The stormwater pipes that they're taught, that the French drain and the stormwater pipes that intercept the groundwater elevations, the seasonal high groundwater stations, will actually circumvent the stormwater rules and in my opinion, violate that recharge part of the ordinance.
Mr. Gall, in other words, they're taking groundwater that's already in the ground that doesn't need to comply with the deficit and putting it in another portion of the property, right?
Yeah, and basically, there's a cubic foot of water that's going into the ground through recharge, what they're supposed to do, but now it's getting the same volumes being pulled out somewhere else. And so they're not necessarily, maybe they're getting some recharge, but they're not getting the recharge that they're required to obtain.
Okay. Is there anything else?
Well, there were a number of issues that I had pointed out in my last testimony that weren't necessarily addressed. There were the issue of the distance. You're supposed to have 2 feet of separation between seasonal high groundwater and the infiltrative surface of the basin. There were a couple of test pits. I'd have to go back to my notes, but that weren't necessarily making that clearance, which is, I think, where they were saying they're going to do their soil replacement, but that's not clear, so I don't think they're meeting the ordinance there. They're not meeting the requirement for the soil replacement if that infiltrative surface or that limiting horizon goes beyond the basin. And also, I know on basin number, I think it's 1, which is the underground basin on the northwest side, there was a couple of instances where there was seasonal high. While they met the seasonal high in a test pit within the footprint of that infiltration basin, on either side, groundwater was actually higher. Seasonal high evidence was higher up. You don't just get a trough in the groundwater. Groundwater doesn't just simply avoid the basin, then you can't do it. I mean, water seeks its level even underground. And I questioned the last time I was here whether or not those soil tests were valid in meeting the intent of the stormwater management ordinance.
Okay.
There may have been other things, but I don't recall. I was really focused on the specific items that were addressed in the
Sure.
most recent submittal.
Okay. Mr. Simon, do you have any cross-examination?
I just have 2 minutes, my client.
John. We'll take a 5-minute recess.
The board will take a 5-minute recess. The planning board will now reconvene.
Okay. So, Mr. Chairman, members of the board, in the interest of time, in lieu of me, cross-examining Mr. Gall based on his testimony, I'm just going to recall Mr. Lamb, just to go through just a couple quick points that he touched upon, and I think that will be more of an efficient use of time for this board. Thank you.
Up to you, yeah.
Okay. So, Mr. Lamb, I'd like you to just touch upon a few issues that Mr. Gall raised. Let's start with an issue regarding the setting of the liner that he referenced.
Yes, can we pull up Exhibit A47, please? When we're talking about the liner on that exhibit, we're referring to the blue lines on the 3 sides of the trench. In order to just simply put this to bed, we could extend that liner all the way to the surface, eliminate any nonsense of back and forth necessary.
When you say any nonsense of back and forth, just be clear about that, please.
About redraining groundwater or the water from the infiltration basin number 5 getting into this French drain, we could eliminate all that simply by adjusting that liner detail.
What do you mean by adjusting the liner?
Raising it, because right now we set it at a minimum. We will agree to it to extend the liner all the way to the surface of the trench itself. So we're going to bring the 2 vertical line up to the surface.
And what will that, by doing that, what are you accomplishing?
It totally prevents any groundwater from entering into this French drain.
Thank you. Next, Mr. Gall talked about these anti-seep collars and their efficacy, and about stopping the preferential path in the stormwater trench. Can you just talk about that for a second?
Yes, look at Exhibit A48, which is in front of you right now. The intent for anti-seep collar is there was a concern about the stormwater trench. The ground is the ground, the water is the water. What it is what it is. But the concern was, will the water from the groundwater enter this stormwater trench because this constructive stone flows easier, which is why we're putting these anti-seep collars to slow it down so it doesn't go into the trench. It goes in the trench, it goes to a certain distance, it hit the concrete. So it's creating a slower, it's no longer creating a desirable path for the groundwater to flow in the trench. And that's what our intent is. And that's what we accomplish by what we're proposing.
Then there was a comment, or comments by Mr. Gall regarding planting trees on the embankments of the basin.
That's quite frankly just silly. The geometry of that berm is
Okay,
silly.
enough. Listen, I get it, okay? But there's absolutely no reason to have that tone, okay? Because in a couple minutes, the public's going to be up here, okay? And while I'm going to expect them, when they're up here asking questions, to show courtesy and be respectful, I'm going to expect the same from you. This individual here, he has not been disrespectful to you. She hasn't been disrespectful to you. You've done it many times. I'm not going to tolerate it. Am I clear?
Yes, sir.
So the comment that was made by Mr. Gall had to do with some concerns relating to particularly trees and tree roots on the embankments of the basin. Can you comment on that, please?
Once again, the trees are planted on the inside of the basin, inside slope. The top of the berm itself is 10 feet wide. The slope to the basin is 3-on-1. Just do simple math, it's 3 feet deep on that embankment height, just for example, 10 feet wide, 3 feet down, times 3 feet to get to the horizontal. 3 times 3 is 9, times 2, and then you add another 10, it's almost 30 feet. So you're saying the tree would go through 30 feet of it to fail the embankment as opposed to being on the inside where the actual drainage and water is available.
So notwithstanding the testimony from Mr. Gall, respectfully, you contend that you do not see an issue with the proposed plantings in that area?
Mathematically, it doesn't make any sense to have a concern.
And then finally, there was a question from, or an issue that was raised by Mr. Gall relating to soil stability based on some fill. Can you just come on that, please?
The concern was about the topsoil exhibit, which was Exhibit A53. About the height of the depth of the topsoil that's going to be adjacent to the curb. Just keep in mind, the curb detail remains the curb detail. The suitable fill underneath the curb is still being proposed. We're not switching that. We're simply replacing the soil on the high side with topsoil available from the site. So the structural stability concern is not there.
So you don't have a concern with regard to the soil as proposed creating a type of stability issue, correct?
No.
Mr. Chairman, I don't have anything further. I think that
I just have one
Go ahead.
conclusionary question after all of your testimony and your responses. You've heard the testimony from the applicant's professional. It's your testimony tonight that you satisfy and comply with all the requirements of the Township Stormwater Management Ordinance?
Absolutely.
Okay. All right. Counsel, do you have any other witnesses you'd like to put up tonight? I think you had indicated one more.
I have no more witnesses. Would it be possible for our expert to respond very briefly to one of the changes to the design that was just made?
Very briefly.
Thank you. Mr. Gall, would you speak to, oh, sorry. Okay, thank you,
Please,
Mr.
please.
Chair. Mr. Gall, would you speak briefly to concerns associated with the impermeable layer extending to the surface?
Oh, no, I mean, it's, the concern I might have there is now similar to the piping is, when they put the watertight seals on the pipe, is now you're putting a liner, impermeable liner all the way all to the top. So now if it's completely separated and you get elevated seasonal high water, well, what will that do to the integrity of the liner? If you ever look at there are always concerns about like putting a lined pond, you know, so they put plastic liners in like large-scale ponds, and groundwater fluctuations can sometimes push it up. So I'm not sure if that would have, excuse me, there's a probability that the liner could get compromised if there's enough pressure on it to, you know, from the groundwater around it rising, you know, coming up and down.
Have you ever seen an engineering design similar to this where a French drain is surrounded completely by an impermeable layer for the purpose of stormwater?
No.
Okay, thank you.
If anything, they could have eliminated it and maybe just put 2 inlets in, and that would have been, they would have been done with it, but.
Okay. So does that conclude all of your experts?
That does, thank you.
So, Mr. Chair, at this portion of the meeting, it's
So
time.
I know a couple of the board members have a couple questions.
Okay, go ahead.
Huh? Oh, you're good?
I have a question regarding the topsoil exhibit, and just for clarification, Tone. The letter dated September 22nd, 2023, right? It's 14,905 cubic yards. That's as is right now with topsoil, correct? In the undeveloped phase.
Sorry, can we repeat that number again?
Yeah, Tung, it's, so 14,905 cubic yards, that's under existing conditions as it is right now?
Yes.
Undeveloped, right? Okay. Now, in the exhibit, it's sheet number C2, it's the topsoil exhibit, the proposed. The green hatched areas, okay, that is where you're proposing to put the excess topsoil when the site is developed, correct?
Yes.
Okay. I guess my question is, if there's 14,905 cubic yards, and then this is saying that the green hashed areas will be approximately 29 inches, is that correct, of topsoil?
Yes.
Okay. What is the, I guess for clarification, what, in the hatch legend, what is this 5-inch thickness referring to and the estimated volume of 2,254 cubic yards? Because I'm looking at an estimated net backfill volume of the original topsoil of 14,905 minus 5 inches, which equates to 2,254. What is that 12,651 cubic yards?
That first 5 inches where we want, like, the best topsoil possible. So we'll screen it, we'll amend it in order to meet the spec of the topsoil that we have on the plans. So for planting purpose, we want the top 5 inches to be like the best topsoil you could have.
Okay, so that's the 2,254?
Yes.
Okay, so then there's 12,651 cubic yards of net backfill topsoil?
That's, if you take 29 minus 5, that's what the balance is.
Got it, okay. So all of those green areas will be 29 inches plus or minus of topsoil?
Correct.
Okay.
Anybody else from the board?
Yeah, and this, I guess, is really more for our professionals than anyone else. Just because we've had such a difference of opinion with the plantings around the edges of the berm for the retention. I mean, can we just get some clarification from?
I mean, it's been very typical of this board to require basin areas to be landscaped along the slope. We can
It's
ask
also
Sherry-
part of the latest green infrastructure that the state put out. They do have an example for woody plants that you could have throughout your entire basin.
Sherry, I don't think your mic is.
It is. Sorry. I was saying the latest stormwater regulations, the green infrastructure actually has as an option, you can plant a basin with woody plant material.
Thank you.
Everybody good?
Hey, Mr. Chair, at this point, it will be open to the public for questions of any of the witnesses, whether it be the applicant's witnesses, the objector's witnesses, as well as testimony. What I would ask, though, first is, counsel, your clients don't have the ability to cross-examine because you've done that, but do you have any clients that want to provide testimony?
Yes, I believe the objectors would like to provide.
All right, so why don't we start with counsel calling her clients to provide testimony? So why don't you do that now?
Anyone?
Okay, if you could just get up to the microphone, and I need to swear you in. You swear or affirm the testimony you're about to provide this board is the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your name and give us your address.
Betty Velez Gimbel, V as in Victor, ELEZ hyphen Gimbel, GIMBEL, 97 Victory Road.
Okay, go ahead.
Okay. So I was trying to keep up with everything as well, because some of the things that I did have may have been answered. So if I could have a little patience from the board, that would be great. Thank you so much for having me tonight. So I wanted to focus on the environmental impact, specifically Ordinance 188-6, where it says, upon completion of all reviews and public hearings, the planning board shall consider the environmental impact record, and if the planning board finds that the proposed development will result in substantial damage to any of the elements of the environment set forth in this section, which is not adequately resolved or avoided by the applicant's proposal, the planning board may deny the application. So I wanted to take a look at number 1, which is the stability of the soil during and after the proposed alteration. So bear with me, I'm not an engineer. However, I'm looking at 87,000 cubic square yards of being imported. An elevation proposed the building about 7 feet above existing grade. Looking at now the topsoil that was just discussed, I've at 15,000 cubic yards, and it was supposed to be removed, but now staying. So my question for that is
There's no question. Your attorney has asked questions. You can make statements, though.
Oh, I apologize. I didn't know I wasn't allowed to ask questions. Okay, so the soil now, the 29 inches plus or minus is going to be on top of that 7 feet of the grade, plus then you now have the building on top of that, which is like 45 or so feet high. So that's quite towering. So I'm left to wonder, and of course I'm not going to ask the question, whether or not now you have the 1,800 yards of clay, the crushed stone, the slab pavement, the asphalt, so you've got about 8,000 heavy trucks round trip coming with all materials to this site. It's very alarming. And of course, let's go to, obviously our brilliant engineer has pointed out that the potential for greater normal total settlements is great, and I would imagine so. As I said, I'm not an engineer, but this is a lot of fill. I'm wondering, leaves me to wonder how the settling of all this compacted fill is going to affect the surrounding homes, my farm, my septic. We've heard North Howell residents crying and pleading their case before the council that their foundations are cracking, their homes are shaking from the tractor trailers and the dump trucks barreling through their neighborhoods. So imagine the fear that I have of this. Going to number 2, the drainage of the same ordinance. Drainage patterns and effect on surface water runoff. So for me, I'm seeing that the drainage is going to the Squonkam Brook, which flows behind my farm along the whole street, and also the Muddy Brook, which flows behind this property as well, okay? I didn't see any study on the impact of the fresh water. There has been an increase of rainstorms that have caused significant flooding to our area. More than before, and I've been there for 18 years, and I have residents who have been there 30, 40 years. And we haven't seen this. And so it is really the average rainfall that they're proposing. I don't know what year it was, I can't remember, but I think we can agree that the climate is changing in some way. Let's see. The GP6 hasn't been approved, and so therefore, that leads me to question, I'm sure that there's some issue there. I would like to touch upon something that the attorney, Mr. Simon, continually touts, the solar application comment. Really tired of it as a badge that you're wearing to try to let us know that you were trying to do the right thing. It's taken out of context. The application for the solar was in front of the zoning board because the applicant wanted to usurp 8 acres of ARE6 into an SED zone. It doesn't change the environmental impact, whether it's a warehouse or if it's a solar field. Doesn't change it. Taking a look that for this is the same lot 17 that was part of the solar application in front of the zoning board. According to the zoning board's denial of the solar proposal, the filling of the wetlands on lot 17 is significant. They also described this lot as environmentally significant land. The need to fill in the wetlands reinforces the common sense that the property is too small for this warehouse. The Environmental Commission and Howell and other boards during this application, solar, described this lot as environmentally sensitive and strongly advised to not remove trees and fill in the wetlands. The DEP report section of the environmental report by the Trident Company listed multiple threatened species and species of special concern, not just the Pine Barrens tree frog. And I have a list that I can go through for you or submit it if you'd like to take a look at it. You have the barred owl, is special concern. Okay, it's threatened in New Jersey. Because why? The habitat. We are losing the habitat, which is what exactly we are doing here. This habitat is for multiple organizations. The pushing out of these species significantly impacts my farm, a produce farm, and places undue financial hardship, and not to mention the strain in trying to make sure that of the surrounding species that are going to be pushed from this lot onto my land, the resources are not enough for these organisms. Nothing has changed about this lot. It's still the same lot that the solar was trying to be put on. Potential, number 5, potential air and water pollution, especially any potential increase in siltation. It's common sense that a 24/7 day a week, over 100 diesel tractor trailers, 85 tractor trailer parking spaces, will the trucks idle during cold days and nights waiting to unload? I don't think we need a study to answer that question. It's just common sense. Number 6, effect of any construction plans or other environmental changes on critical slope areas or sewage disposal systems. The septic system hasn't even been approved. Why? Because they want a 24/7 operation, and it has not been designed for that. How do you know it's going to fit in the borders within the riparian buffer? Do you have room? I don't think so. This actually brings me back to May 4th when your engineer couldn't answer any of the questions that I considered really important, such as being asked about the calculations, and I quote, Tung To Lam, "I don't know, I haven't constructed my math yet." Again, asking, what's the approximate fill? Can you answer that? Not at the moment. The attorney, Lieberman, again asks, are you keeping the topsoil on site? No determination. And are you aware of the amount? I am now, of the soil that's supposed to be removed. Very disrespectful. And so, moving to number 7, I'm not sure if rock is being removed from the site. I haven't seen. Number 8, the amount of resulting non-agricultural displacement of soil. We've already talked at length about that. The storm, number 9, potential noise pollution. What's the expected noise level increase of the proposed 24/7 day operation in total? 109 tractor trailers coming in and out, waiting in the lot, 25 loading docks, additional cars, employees. Did you know that the 1,500 trees on this lot and the surrounding lots presently serve as a sound barrier to the New Jersey gas liquefaction tanks and the warehouses on Oak Glen? Are you aware of the 2 new warehouses on Oak Glen diagonal from this site, just approved by the zoning board? Again, taken out of context, this solar badge you wear. Number 10, increased in the amount of industrial waste. Well, we don't know who the tenant's going to be, so I guess we'll mark this unknown too. Where's the common sense in all this? The tenant is unknown, therefore the use is unknown. Therefore the amount of industrial waste is unknown. And then we're submitting plans for multiple office spaces, but we're not going to use those. We just put those in there, but we're not going to use them. Number 11, Increased problems of industrial or non-industrial waste disposal, such as the review of the problems with the Board of Health. Will there be an increase in problems of industrial or non-industrial waste? Again, the applicant doesn't have a tenant, so we don't know what activities are going to be placed. And we're not sure if it's going to be 1 tenant or 10. What we do know, and correct me if I'm wrong, is the applicant's plan is a 24/, 7-day operation. Over 100 tractor trailers coming in and out. 85 tractor trailer parking spaces. What can we expect? What we can expect are strangers coming from all over the country and possibly across borders, which is what a 24/7 operation brings. A more common description used by CDL drivers, truck drivers, is a gypsy driver, a driver who has no ties to a particular corporation, which enforces accountability. And without this, it introduces a level of danger to the residents, thus affecting safety. We, the Victory Road residents, hired an expert engineer, Jeff Gall of Princeton Hydro, to review your proposed plans. The stormwater management and all your little adjustments do not work and significantly impact the surrounding environment. How many chances do you get to revise, to revise, to revise? As an educator, I would not permit that many revisions. You should know what you're supposed to do and not guess it or be schooled by our expert. We, the Victory Road residents, hired a traffic engineer. Just knowing he was on board was enough to keep everyone on their toes. And finally, our legal team, which we undoubtedly needed on this most difficult journey. We are emotionally spent, in debt financially, upwards of almost $60,000. Our lives have been completely disrupted, and our future as a Howell resident, my future as a Howell resident, is in question here. It's up to you, the planning board, to decide which experts you agree with. The applicant will do what is best for the interest of the application. Our team members have reputations to protect. Our small farms are an asset to this community. And we have big plans, which will continue to be an enormous asset to this community. And I take offense to those who, in a negative tone, label me an activist. I am not an activist. I am a resident trying to protect my home, way of life, and offer something to the community, which has always been in my heart. We've worked so hard to live here. And we love Howell, but we don't want your warehouse. And we expect more of so-called professionals than the arrogance that you have shown today and the disrespect for our way of life and everything that we've worked so hard for. You should be ashamed of yourself, and I can see that you are because you can't even look me in the face. Thank you so much.
Council, do you have any, Mr. Fitzgerald? Do you have any other clients, counsel, that want to testify?
So, hang on one second, Mr. Chair, usually we stop at 10 o'clock. Does anybody on the board have any objection to just extending it to 10:30? All right, so we'll extend it to 10:30 so we can get some more people in tonight, all right?
Okay.
So I just want to put that on the record.
Sir, do you swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your name and give us your
My name is
address.
Robert Wagner. My address is 1551 Maxim Southern Road. I was in the Marine Corps, I was a correction officer, Rikers Island, and a police officer, retired. I volunteer at Meals on Wheels, 2 days a week, I volunteer at Meals on Wheels 2 days a week, up to 4 days a week. I moved to this county 2017. Nice county. Animals, everything. People are nice, okay? I want to have respect for you people. Sir, I don't have respect for you. You're the lawyer for this county. I don't have no respect for you. This lawyer and his client were having a problem answering a question from counsel. You helped them out answer the question. Now, you're the county lawyer. You should have just been very straightforward and let them try to figure it out. But since a lawyer and the architect, or whatever he is, can't answer the question, I have a question about you then. Now the integrity, right here, I have a question with. Who are you representing? Okay? This is a good county. You don't need the warehouse. Okay, I understand you want to bring taxes, you want to bring business. But the fact of the matter is this. This is going to destroy this place. If you go to New York City and you want to see trucks, traffic, okay, you go to Lower East Side. All right? Traffic is phenomenal. You are going to have 25 bays? You go to Oak Glen, you got 3 warehouses, or a warehouse with 39 bays, and you got 2 other buildings over there. I watched tractor trailers today. They have no route they take. They take any route they want to take. Mrs. Velez is right. They will do what they have to do when they got to get where they got to go. I worked for Brinks. We had armored car trucks. We had tractor trailers. They come from out of state. They come from out of the country, and they deliver. And they have a schedule. They have a time element, okay? Some of their trucks are not working properly. Some of their trucks are throwing out the fumes and stuff like that. When I drive around in the Meals on Wheels, okay, I will tell you this. These little roads back here, they can't handle your big trucks. I see dump trucks coming by, 40 miles an hour, 45 miles an hour. But what is their weight, their tonnage? I have a little Toyota Prius. I move to the side because they're coming over the double yellow. And the bottom line is they're coming onto oncoming traffic. Now, if you go down Victory, you go to Oak Glen and Maxim Southern Road, okay? I'm standing over by the community church one day. And here comes a dump truck coming down Oak Glen towards Maxim, makes a left, takes 2 car lengths on the oncoming traffic that has to stop, and almost hits me when I'm talking to one of the people by the church, okay? These people don't know how to drive their trucks. They don't know how to drive the tractors. You're going to put them on these little roads. So I got a question for you. Somebody gets killed or seriously hurt, and are you going to take responsibility for it? If you are going to approve this...
Don't do that.
No,
Okay,
why not? Why not? I have time to speak, correct, sir?
Well,
Am I being respectful to this board?
Mr. Chairman, the comments have to be relevant to what we're reviewing.
Okay, relevant, I'll take that away, okay? I'll take that away. People are going to get hurt. They're going to get hurt. It's not a question of they're not, they are, but when? And what kind of injuries are going to occur? There's going to be death. There's going to be serious maiming injuries. You got heavy trucks on these small roads. They shouldn't be there. We live here. We're going to suffer. We're going to suffer severely. There's going to be flooding. There's going to be everything that they talked about today. But my question today is, sorry, sir, you should never help them answer a question. They should have been, he gets paid enough, and he's an expert, and they should have knew the question she was asking. Thank you for your time.
Have a good night.
You have any more clients, counsel? You swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your name and give us your address.
Marjana Scarselli, 191 Victory Road.
If you could just spell your name for us.
Mirjana. Last name Scarselli, Scarselli. We're fairly new to Howell. We moved here 3 years ago. I live with my mother and my daughter at 191 Victory Road. And we come from Staten Island, New York City, Brooklyn. We are no strangers to the city, the trucks, the traffic, the pollution, the noise. At the time, it was soothing. We are a 9/11 family, an FDNY family. We moved for a better life, a better quality of life. We had a community that raised us after that. And we moved here 3 years ago. and we found almost the same thing on Victory Road. And as a single mother, I wanted to give my daughter a safe place to grow up, better school system. The people are better, no disrespect to New York, but the people are better. Everything about it. Victory Road, the landscape, the farm animals everywhere. It was like the American dream, especially during COVID. We moved during COVID. We wanted to be self-sustainable. We didn't know where the world was going. And to us, this was our dream. This was our forever home. This is where we wanted to end up. Now, we're faced with a 200,000 square foot warehouse. And what concerns me the most, I share all the concerns of my neighbors. My daughter gets on and off that bus every single day, 5 days a week. In the evening drop-off, she gets off the bus from across the street because the route can't accommodate coming in front of the driveway. The bus has to pull in the middle of the street just to let her cross because he's nervous. For 2 years, 6th and 7th grade, I sat out there because my nerves were shot. But it's a 50-mile-an-hour road. God forbid. 2 years, I sat out there morning and evening. The cars that came through, by the end of the 2 years, rolled down the window, waved hello. They were the same cars. It must have been their cut-through, a normal road for them. Never anything out of place. It was like a normal day every day. So now in 8th grade this year, she can get on the bus herself. The fact of all these tractor trailers and cars coming in to and from work scares the life out of me. And it's not going to be a place that I want to raise my daughter just for that fact that I have to worry for the next 4 years of her getting on and off the bus. Or when she starts driving and she's coming out of the driveway, sometimes I have cars right up at the back of my car when I'm making a right-hand turn out of my driveway that I didn't see from my long fence. There is no sign to slow down on the S-curve. It's a 50-mile-an-hour road. The road, you're able to pass on that road right up until the front of my house. So if somebody's aggravated with the way how slow somebody's driving, I drive only 35, 40 miles an hour on that road. I've gotten past so many times. The one car that passed me was actually the car that got hit by the train last month. Okay? Who's to say they're not going to try to pass another car and slam into my daughter's bus or while she's crossing the street in the PM? These are the things I worry about as a mother. I didn't move here for that. I did send an email to Mr. Cucciaro and the board regarding that the planning board do their own traffic study and their own quality of life study, and I never heard back. I think I emailed twice. I never heard back, and I think that's so important because what the applicant is saying as far as their traffic study to what we observe every day are two different things. And I'd keep it short and simple. I stand with my neighbors. Again, I am new, but I know community. I love this community. I love Howell. I want to be a part of it. I don't want to go anywhere. And if this warehouse is built, we will have no choice but to leave because I will not raise my daughter on a road where tractor trailers are driving, air is being polluted. I mean, we have garbage on the side of the streets now, right? There's pros and cons to every neighborhood. I knew we were on a road like that. I pick up my garbage, whatever's dropped on the side of the road. This is going to bring more pollution to a beautiful neighborhood, and it's just not okay. Thank you.
Mr. Chair, just for purposes of the record, the board's traffic engineer did review this, and in conjunction with our board engineer, put a report together, and the traffic engineer is also here tonight. So there was a traffic review by our traffic engineer.
Okay.
Counsel, you have any more clients?
Is there anyone else? Anyone?
Just your clients at this moment. We'll open it up to everyone else after that, but. Okay, sir, do you swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
I do. My name is Chris Bates. I live on Victory Road. I've lived there for 18 years. I don't have a whole lot to touch on because I think they've covered much of it. But I do have to bring up that I think the entire project is completely inappropriate, unnecessary, and I have to honestly say, I just met a lot of these people for the first time in the past few weeks as I've really started to get engaged. And these people are traumatized. I've seen numerous people break out in tears, people that look like they haven't slept for days. This is their community, and they're really counting on their public officials to step up for them. I mean, we're floundering here. We're not rich people, we're small farms. That's what we knew we were moving into, and we're up against big money. And I can honestly say that myself, I'm in it for the long run. I'll do whatever it needs to do. I've already told my girlfriend, no vacations, because I'll keep funding it and keep fighting it, because it means so much to these people, many of whom are older. They've been there for generations, and they're on fixed incomes. And their neighborhood is going to completely transform. I mean, we bought 6.5-acre lots 20 years ago with the condition that we were going to keep 4 of those acres untouched woodlands. And I've never even been back past my wood line because I don't want to disturb the ecosystem. But I think, yeah, we're in this for the long haul. No matter what you decide, I implore the board to do the right thing and deny this application. But no matter what, I'm not going to walk away from it. We're going to keep fighting. Thank you very much. Thank you.
Anyone else? Are we done? Please, please.
I'm not an objector.
Oh, just of my group, if anyone else wants to come up, please come ahead. Okay, that's all.
That's
Okay,
it.
so then we'll open it to the general public not represented by council. Since the general public was not represented by council, you can ask questions to any of the experts and also provide testimony. So anyone can come up to the mic. You swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your name for the record and give us your address.
My name is Peter Guilfoyle, Guilfoyle, 47 Victory Road.
Okay, go ahead, sir.
I have a couple of concerns. One is I live north of this proposed warehouse, and I believe you've said that there'll be no trucks going north, which after hearing the testimony at the council meeting about the Victory Road, the Fairfield Road residents, the truckers don't obey it there, and I'm sure they won't obey it here. So we know this truck's going to come north on Victory Road, and that means they have to turn onto Maxim Southard and then engage Maxim Southard and Oak Glen Road, which is one of the most dangerous intersections in this city, in this township. There's accidents there at least monthly, and I'd say weekly. There's no way they can make the turns currently, certainly not going north without crossing over into the other lanes. So we're going to have to deal with that. There's going to be accidents there. Also, where I live, it's a hidden driveway, and when those trucks come around that curve, they're going to encounter me someday, trying to come out of my driveway. I know that, and that concerns me. So that's been one of my concerns, is the traffic going north. One of the others is the applicant is putting in a septic system and city water. Now, I don't know why the applicant can't put in a well like the rest of us do. We have a pretty good environment going there right now. We take water out of the ground and we put water back in. They want to add 2,500 gallons a day of water into this ecosystem, which, since the water already spills off into our properties, that extra 2,500 gallons is going there too, because that's going to come in through the city water. In addition to that, when they tear up the road and put in the city water, They're going to thank us by giving us a bill for about $300,000. There's 20 residents on that street, and our properties are pretty far, houses are pretty far off. And so it's going to cost us between $10,000 and $20,000 a piece to hook up to that city water, and we don't need it. I have my septic pumped every 2-3 years just to keep it going. Everything is working pretty good. As far as the water runoff, I've noticed in the last, with the rain we've had, the deer are starting to come close to my yard, and they don't. They always stay back. They're coming up close to the yard because the water back there in the wetlands is getting more and more soaked. And they're coming up just for a while. I know they'll go back there, but that's how much water we have. And as far as trees falling down, the gentleman said before, I just cut one up today that fell right over because the water is the ground is so saturated. So those are real things that are happening. And what I'm concerned about that extra $20,000 a piece that we have to lay out. Some of the houses are 400 feet off the road. You know, even at $100 a foot, that's $40,000. Just to save the applicant the cost of putting in a well. Here's my other, we're not sure the electrical grid can handle this either. I don't know if you've studied the electrical situation, but, you know, I have a generator, of course. I turn it on monthly because that's how often the power goes out. What is this mega warehouse, it's mega to us, going to do to the electrical problems on the street? We're constantly losing power, and I don't know if that's going to help. It's not going to help. I don't know how it's going to be resolved. The last thing I want to bring up is the widening of Victory Road and the fixing of Victory Road just to accommodate the applicant. The applicant says that you've got to approve this because it's zoned for a warehouse and you have no choice. You do have a choice in setting parameters of how it's built. You can cut back the size of the warehouse. You can cut back the hours of the warehouse to be reasonable. They put in their plan 1,700 gallons of water a day because they only calculated one shift. Why did they put 3 shifts, 24/7, in their application if they're only contemplating one? It's because they want the right to do it. You can do that. You don't have to accommodate. The township does not have to accommodate them by widening Victory Road, knocking down the trees that are protecting the houses that are closer to the road, and putting in what? I don't imagine there's lights going up there, is there? There's supposed to be reflectors going up to keep the trucks safe. Knocking down those trees is a big deal when you take some of these houses that live on that curve. And that curve, by the way, is part of the beauty of Howell Township. That S-curve that's in there is part of the character of Howell Township. And a lot of people know about that curve. And a lot of people know about the alpaca farm that lives on that road, and the bee farm, and the bamboo farm, and the horse farms. I mean, Howell Township is known for a lot of the activities on Victory Road. And we're supposed to, according to the planning board, try to maintain the rural character of Howell Township. And I'm asking the board to consider some of those ideas. Thank you.
Thank you.
You swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
Yes.
Just get close to the mic and state and spell your name for the record.
Yes.
And give us your address.
Patricia Isbrecht, 615 Fort Plains Road.
Can you spell your last name for us?
Isbrecht.
Okay, go ahead, ma'am.
I'm here today to ask the planning board to not destroy these people behind me quality of life the way my quality of life was destroyed with Walters Group Affordable Housing. I see many of the same expert testimony here tonight as I did back with the Walters Group. Walters Group no dirt in, no dirt out. That property is now 6 feet higher than me right next door. No berm for my property next to Walters Group. It was not until I had to alert the township and all of Facebook that my property and my neighbor's property were flooding. I have a septic system and I have a leach field. Tommy Russo had to come to my house and was the only councilman who came to my house to view that flooding and to demand a berm goes up. My quality of life has not been the same since Walters Group. Now, on Fort Plains and Sunnyside, you're going to rearrange that to an astronomical amount. That road can't handle it. We didn't need a light on Fort Plains and West Farms. Now we need a light. You arranged exits out of the Walters Group, so you could only make a right-hand turn in from Fort Plains Road and a left and a right turn out of the complex. I had Santa Claus and the fire trucks making a left-hand turn out of Walters Group down Fort Plains Road. So if the fire department's not going to obey the road signs, what makes you think any other public is going to? So please, I beg you, do not destroy their life the way you destroyed me and my backyard. Thank you.
Do you swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state and spell your name and give us your address.
My name is Stephen Mirabello, live at 2 Flintlock Drive.
Just spell your last name for us.
2 Flintlock Drive.
Sir, can you just spell your last name?
Mirabello.
Okay, go ahead, sir.
Hi. So I've had the opportunity to go and take a look at a lot of the environmental reports of Phase 1, Phase 2 that have been in these applications. One for the initial warehouse application, and also even going back to the solar farm that was proposed before that. And in doing research for the property at hand, I've also looked at New Jersey DEP data miner and looked at some of the environmental concerns for the properties that are surrounding it. So in the Phase 1 and Phase 2 that discussed the environmental impacts on the property itself, but there's also so there's been some contradictory information between those two reports. So I have some concerns in taking a look at that there's some gaps there, and I'm not confident that all the environmental issues for the site have been properly addressed. So for instance, and if you take a look at the available groundwater data from the stormwater reports for the test pits, it's unclear whether the groundwater flows to the north, to the DeSanti property, which is in the New Jersey DEP data miner, or if it flows onto the site from that property. And one reason that is particularly relevant is the investigations on the property to the north they're still active, still ongoing. There's no real public data. It's an incomplete record for what's there. So to me, there's still a potential risk that there could be contaminants flowing onto the site. When you take a look at the Phase 1 and Phase 2 reports that were provided, initially for the solar farm, the recommendations of the LSRP for that had said that in his opinion, the proposed use of the solar farm was appropriate. However, if they want to go and change the property use to warehousing, he would recommend doing a report for vapor intrusion to see if there would be any volatile chemicals that might get into the warehouse and might affect the workers. I haven't seen any such investigation that would happen currently. And I don't know if the current warehouse takes into account some sort of vapor barrier or subslab system like you'd have for radon to go and mitigate any vapors that may be there. When you take a look at the reports, phase 1, phase 2 reports done for the warehouse, they describe that there's still actually some areas of concern, AOCs, that would still need to be investigated. And I think part of their plan is to go and do their investigations, test pits, as part of the concurrent with construction. So I certainly have a concern is that in getting into this process, they may discover, unearth that the contamination that may or may not be there is much larger, and now the proposed site use of warehouse is completely inappropriate for the cleanup or the site remediation they may need to do. So, and just going back and thinking about recent events in our town, just not too long ago, we can think of what happened at Mall Road, where that contamination still isn't cleaned up. There's still groundwater issues. That's been known about for 30 years on now. So my recommendation is to go and wait until all the environmental investigations are done for this subject property, for the property to the north, have all the environmental professionals and the board an opportunity to review it before we even go and put something in place that may be wholly inappropriate. The best time to do any sort of cleanup is now, before anything ever gets built and we have to make any sort of accommodations. So I would recommend to wait until all the environmental work is completed. Thank you.
You swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your name for the record and give us your address.
Nicole Woolley, Woolley, 223 Victory Road. I was born and raised on Victory Road and have several family members still living there. My parents moved there in 1964. We have local knowledge about the area that outsiders do not have. We have an appreciation for the character of the street and the environment that the applicant does not have. A warehouse will turn a quiet, rural back road with farms and residences into a high-traffic, unsafe, loud, aesthetically unpleasing street that will negatively affect our property values. I have a few questions. Has a quality of life study been done?
Who you're asking the question to?
I don't know.
I guess it would be to the applicant.
To the
So,
applicant.
Mr. Simon, let's hear the questions, and then Mr. Simon will respond and
And then I have
perhaps
comments.
call up
Yeah,
any of the witnesses.
Right, I can't provide any testimony, but I will identify the
Okay.
witness that I think is appropriate to answer the
Okay,
question.
so go ahead. Let's
And then I have comments after the questions. Is that okay?
well, let's get the answers to the questions
Okay.
first.
Has a quality of life study been done? Has there been a study on the runoff and its potential effects to Squonkam Brook's wildlife and plant life and to our drinking water? That's more of a concern. Have tractor trailers turning onto Victory at rush hour with the car in the other lane been actually attempted from both directions, not a simulation? I think those are all my questions.
Okay, so, Mr. Simon, do you have
Yes,
witnesses?
So when you say a quality of life study, just so I can identify the proper witness, what do you mean?
Mr. Simon, just get closer to the
Yeah,
mic.
I'm sorry, I'm trying to,
Well, I mean, it entails a lot. It entails about the air pollution, the light pollution, the noise pollution, how it's affecting our homes, our everyday life, our safety.
so
I
who,
can go on.
okay, so that's one, and then you have a question about stormwater
Yes, runoff.
runoff, and then you have a question about tractor trailers.
And then Kerry, why don't you come on up to answer the question? I'm sorry.
Okay, so this is our engineer, who, Tung To Lam, who's provided testimony. Why don't you ask the questions, I think the quality of life maybe question and the stormwater question.
Have there been any quality of life studies done?
Environmental impact statement has been submitted to the board.
how it
So-
affects our quality of life, not just the environment and the animals.
For this property.
Well, why don't you explain what the environmental impact statement contains? What elements does it address?
There's a checklist based on the township requirement on what needs to go into the environmental impact statement and the natural resource inventory, and those has been submitted.
Well, some specifics, please.
Bob, do you have a copy?
Yeah, hold on a second. So, I suggest, this is environmental impact study, why don't you talk about all the data?
If you refer to page I, which is the table of content for the environmental impact statement prepared by EcoScience Incorporated, March 2nd, 2022. It goes through a list of items, and in fact, it's 2 pages of table of contents. It starts with a description of the development, the project alternative, inventory of existing natural resources, assessments of environmental impact, steps to minimize environmental impacts, irreversible and reactive commitment to resource, unavoidable impacts, and then the rest are license and reference. But in each one, there's subcategories to it. For example, under inventory of existing natural resources, it talks about the geology, topography, the soil, the groundwater quality, the surface water quantity, vegetation, wildlife, wetlands, aquatics, floodway, floodplain, air qualities, sound, land use, aesthetics, historical, cultural resource, demographic, and that's just one sample of it.
So in response to the question in terms of quality of life study, you contend that the environmental impact report and its subcategories that has been submitted to the board addresses issues that would go into such study, correct?
Yes.
And I apologize, ma'am, with regard to the stormwater question, can you just repeat that question just so I get it accurately?
Yeah, just for the sake of time, I'm good with a yes or no answer. Has there been a study on the runoff and its potential effects to Squonkam Brook's wildlife, plant life, and our drinking water?
No, the stormwater impact is designed for this property, not beyond.
So, no, there hasn't been any study about the runoff affecting that. Okay. And the last question was about the tractor trailers. And again, a yes or no for the sake of time would be fine. Have tractor trailers turning onto Victory Road at rush hour with a car in the other lane been actually observed, attempted from both directions? Not a simulation, but actually having tractor trailers do this.
No, we don't look at it that way.
Okay, that's good. Thank you. Okay, thank you. Okay. Okay, I'm concerned with the effects that pollution and disturbances will have on the health and quality of life of the residents, pets, farms, animals, and numerous wildlife species due to the increased human activity and tractor-trailer traffic, increased cars and trucks, and construction vehicles creating noise, air, light, and light pollution during the construction phase and once the warehouse is operational. Some concerns pertaining to the financial impact. In addition to the waterline and probable decrease in property values, damages to the homes will add to our financial hardship. Victory Road was not intended for such heavy traffic. My concern is that the taxpayers will have to bear the expense of the road repairs. My family will be negatively affected even more so since most of the land they are proposing to take is from the front yards of our properties. This is so a rich businessman from New York can make money at our expense. How is that just? Farmers' livelihoods are their land, and their nest egg is the property. What happens when their land loses its value? Regarding traffic and safety, as a person with local knowledge, I feel confident in saying that the traffic impact will not be minimal.
tractor trailers will be backed up from 547 down Victory, blocking driveways and spewing fumes into homes. At rush hour, the backup could potentially go as far down as the S curve, which would be very dangerous. And what about the tractor trailers passing the mailman on the curve when a vehicle is coming in the other direction, not to mention all the hidden driveways? The other day, I was unable to turn left off of Easy Street onto 547 South due to the traffic being backed up from Soldier Fields past Easy Street almost to Victory, and it wasn't even rush hour. I can only imagine the traffic once tractor trailers are added to the mix. The roads are narrow, without shoulders. People ride bikes, walk their dogs, and ride horses. One neighbor's geese cross the road several times a day. What will be done to ensure the safety of the people and their animals, In addition to the danger posed by the trucks, the farm animals, wildlife, and pets will be startled and stressed by the noise. Widening the road to supposedly soften the curve will not help. Eastbound cars speeding don't just cross the line. Quite a few have ended up on the other side of the road in my front yard. The danger will only increase with tractor trailers routinely traveling Victory Road. To think everyone, including truckers on a schedule, are going to slow to 25 miles per hour is unrealistic. Tractor trailers going around the curve, crossing over the lines due to their size at the same time as another vehicle traveling in the opposite direction is a tragic accident waiting to happen. Signage will have minimal impact at best. It would just be a matter of time before someone is killed. As far as the signage, where will the speed limit, curve ahead, yellow arrows, and truck tipping signs all be located? My front yard. Not only junking it up, but taking even more of our yard. What the applicant calls improvements, I see as useless Band-Aids that are ruining the beauty of my yard and street, not to mention my property value. Victory is a rural road. Trying to turn it into a city road is not an improvement. And if you bear with me just one more minute, I would like to, my brother wasn't able to be here today. He lives across the street from the auto body. And to say that that easement is an improvement, that it's for us, that everyone could use, well, every single person here on Victory Road will agree, it is not for us. It is for that warehouse, and you're going to promote those tractor trailers to go by our houses, to be sitting outside my brother's house. They talked about the study wasn't done about the runoff. Well, that runoff will go right into my brother's fields and ruin his trees, which is his livelihood. So don't spin it that it's for us, that we actually need that, because we don't. I'm sorry. I just want to make sure that I mentioned that one other thing about for my brother. Ridiculous that they won't turn right off of Victory. There's Brick, there's Lakewood, there's Route 9 South. If it wasn't necessary, they wouldn't have paid money for the easement, for the property. The neighbors are greatly affected. The fact that they weren't notified is sad. If my brother didn't care about the quality of life, his own and our neighbors, he would have sold out too and sold the corner of his property when he was approached. But he didn't, because quality of life is more important than money. Thank you very much for your time. I appreciate you listening to my passionate cries for helping stopping what would be a devastating nightmare.
All right, it's 10:29, and there ain't no way you're done in 2 minutes, Mark. We know better.
You want me to surprise you? I don't think I can be done 2 minutes. With all respect, can we go an extra 10 minutes? I'm only going to take like maybe 5 or 6 minutes.
You take 5 or 6 minutes?
Yeah.
You swear? You guys okay with it?
You swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
Yes.
Please state and spell your name and give us your address.
Mark Parisi, Parisi, 2 Castle Court. All right, good evening, thank you for the time. I know there's been a lot of talk about the easement. Has that been entered into evidence as an exhibit? If not, I have a copy. Can I enter it in as a public exhibit?
Well, you can enter in whatever you'd like, whether
Well-
it has been entered or not. If you want to submit something, go ahead.
I'm talking the actual easement, the
I'm telling
deed.
you, if you want to submit something to make sure
Yes.
that your point is made, go ahead.
Okay, so who should I give
So
this to?
mark this as P1. Do you have an extra copy for council?
I don't, but I mean, it's a public record. It's the recorded deed for the easement.
Why don't you just show it to council first to see if he has no objection?
All right, so I'll just get into my testimony since I'm now only 5.5 minutes. I have concerns that the applicant did not comply with the local ordinance related to public notice. Ordinance 188-5.1 regarding notice signs states all applications requiring public notice as here and above set forth shall require a notice sign. A notice sign is a sign which is freestanding and erected on the property which is subject of an application for development. Notice signs are required to be created on the property which is subject of an application for development. State the name of the application, blah, blah, blah. Sign's supposed to be between 32 square feet in area and 64 square feet in area. It's supposed to face the street abutting the property. I never saw such a sign erected on the property. I don't believe they were granted a waiver, and it's my understanding that this applicant did not comply with this ordinance requirement. That's ordinance 188-5.1. I have a statement about some traffic stuff and then a question for the traffic expert. Victory Road is a local road. This planning board adopted a new circulation element of its master plan in May of 2022. The planning board had the opportunity to recommend changing the designation of this road, but they did not. The goals of the circulation element included, and I quote, remove high-intensity uses from areas where roads cannot support, end quote. Another goal was, quote, relocate high-intensity uses to appropriate roadways and discourage development on lower classification roads. As I said, Victory Road is a local road. It's the lowest classification. This applicant is proposing to make significant off-site improvements to Victory Road to accommodate tractor-trailers using their warehouse. These proposed improvements include widening the S-curve and reducing the speed limit so trucks can safely pass each other on the S-curve, as well as obtaining an easement at the corner of Victory Road and 547. The easement states, Council, are you guys okay with me entering that into the record?
We're marking it as P1.
Okay. The easement says, quote, to enable tractor-trailers to make right turns from Victory Road onto Lakewood Farmingdale Road. That is the specific purpose of the easement. It says so in the recorded deed. I want to draw the board's attention to ordinance 188-118, titled Streets. It states, quote, local streets shall be designed to discourage through traffic. So my question for your traffic expert is it her professional opinion the proposed improvements will encourage or discourage through traffic on this local road? Now, in the interest of time, I don't know if you want to bring her up here and answer the question, but I'll just opine that I do not believe that I do believe that these proposed improvements are inconsistent with that ordinance and that they are going to encourage through traffic. By changing the S-curve and redesigning Victory Road, you are now going to have traffic that is on Maxim Southern that is going to say, hey, I can cut through Victory now, and that goes against your ordinance 188-118. I think it's important that the board knows that the Monmouth County Planning Board has designated 547 as a scenic road. This project is going to increase traffic that's going to be using 547. That's inconsistent with the Monmouth County Planning Board. I urge the board to deny this application and not allow them to make the off-site improvements for those reasons. Question about, is Victory Road a residential zone or an industrial zone? Well, I did a little unscientific math, and basically 90% of the frontage on Victory Road is residential. But for the steel factory and this property, those are the only two lots on Victory Road that are not zoned ARE6. So it's fair to say that Victory Road is a residential road. And since like 90% of the frontage is residential. So this applicant's proposing to operate a warehouse distribution facility 24/7 in a residential zone. I looked at the list of all the permitted uses in the SED zone. There's very few uses in there that would operate 24/7 except for this warehouse distribution. I believe that consistent with what has been written in legal briefs from Mr. Cucchiero's firm, it says the planning board has the power to impose certain conditions on site plan approvals, and then goes on to quote a case, or what is that? It's from Cox. It says, the board unquestionably has the right to impose reasonable conditions. The condition was an exercise of the board's quasi-judicial power. So I asked this board not to deny the application, but if you're not inclined to deny the application, that you condition this, any approval on, and limit the hours of operation on this warehouse, and that you have the authority to do that, that you would limit the hours of operation to 7 a.m. to 10 p.m. or whatever discretion you believe is appropriate, since you're now putting a non-residential use in a residential neighborhood, and you have the authority to do that. With respects to Exhibit A49, which was the exhibit that was talked about in the beginning of this hearing tonight, in which it was submitted, into the record, and then council said that they didn't intend to rely upon that. I think it's very skeptical that they entered into evidence a site plan that shows that they're increasing the office spaces from 2 office spaces to 6 office spaces. To me, it looks like a flex space type of operation where they're going to have multiple different tenants in that building that are going to be operating with different uses. I don't know, there was no testimony as to whether or not, all of the potential tenants are going to be operating as warehouse distribution, or they're going to be operating as other types of uses. But I do think that it's important to know that with respects to the amount of loading bays on this building, that the State Planning Commission on warehouse guidance says that the industry standards is 1 loading bay for every 10,000 square feet. This building, I believe, has 26 loading bays. The Exhibit A49 had 28 loading bays on it. It's 190,000 square feet of warehouse space. So they technically have between 7 or 8 or 9 more loading bays than are required under the industry standards. Why? And if they are intending to use flex space, which I don't know what they are, if they plan to do that or not, but they certainly don't need that many loading bays if they were going to use flex space. I mean, maybe 1 bay for each unit. So I would encourage the board to be skeptical about what their end game is with this actual building, based upon their submission of Exhibit A49. There's no reason this building needs to be 45 foot high and have 40-foot clear ceilings if they're going to be dividing it into 6 separate units. They could easily have turned around and limited the building height to 25 or 30 feet. That would fit the character of Victory Road. There's no structures on Victory Road with that high. Paul, I'm trying to go through it as quick as I can.
You got it.
Okay, all right. So, I would just respectfully submit that that there's no reason why this building needs to be as large as it is and literally consume and take over Victory Road. They could have, if they really wanted to fit into their neighborhood, they could have moved this building back off of Victory Road, maintained wooded frontage along Victory Road, reduced the height to 25 or 30 feet, reduced the size of this building substantially, maybe in half, reduced the number of loading bays and reduced the number of trucks that are coming to this building. There's so many things that they could have done that would have probably been acceptable to the residents behind me and to this community and maybe to you guys, but they chose not to do any of it. And this is the application they put forth, and this is the application that you have to now consider. And with respects to exhibits B20, B27, B38, the septic system was denied by the county health department in August of 2022. They haven't put any testimony. I haven't heard any testimony as to whether or not they've submitted plans to the DEP for a new septic system. We don't know where the septic system is going to go. We don't know how big it has to be. I don't even know how you can approve a site plan without knowing where a septic system is going to go on the property. I mean, I've watched a lot of planning board applications. I'm shocked that there hasn't been any statements from any professionals anywhere that says, how do we know? Where are you putting your septic system? How are you going to engineer around a septic system that needs an outside agency approval? It's just shocking to me that there hasn't been more comments about how can we approve where your slab is going to be, where your basins are going to be, where your parking lots are going to be, or anything, when you haven't even presented to us with a concept that you've provided to the DEP regarding the size of your septic system and all the requirements that under state law. It blows my mind. So those are my pretty much everything that I want to say. My last thing that I want to say to you guys is just more of a personal note. You guys are like a jury, okay? I mean, you've heard 2 sides of a case, and now you got to decide who you believe more. And, that's up for you guys to decide. But you've heard, the applicant's story, the objector's story, and it's my understanding that if you guys were to decide to deny this, and you say, we believe the objector's experts in their testimony, and we find that the applicant's testimony was not credible and not reliable, that a court's not going to overturn your decision, as long as you can explain and come to some reasonable basis as to why you denied this application. And I'm asking you to deliberate and do that tonight. Thank you.
Mr. Chairman, just one note on the comment regarding the, excuse me, the notice signs. The New Jersey courts have held that those requirements are invalid. There was a case in Edison, a similar ordinance. The court said that the notice requirements in the municipal land use law prevailed and that you couldn't require greater notice than that. So a lot of towns tried, but the courts have said that it's not something that you can enforce.
Okay.
So with that, we have taken a look, Mr. Chair, at some of the upcoming agendas.
Okay. Well, for now, let me close public portion. For now.
We have on October 19th, we have our master plan hearing. That may take some time.
Okay.
And we have the Wadsworth application, which is a Whispering Woods application that the court requires us to proceed with. And we do have some other larger applications on that night. So I would not recommend October 19th. November 2nd, we may be able to get this done. And then we have December 14th as well.
Yeah, so
It's my understanding there's a consideration to carry the application until November 2nd, 2023, without any further notice to the public.
That's correct.
My only question is really a procedural one in terms of whether we would need to bring all of our witnesses back again, in which case I'd have to go poll them and find out about their schedules.
Well, why don't you take 5 minutes and do that? Because the answer is yes, because the public has the right to cross-examine, so we'll give you some time to pull.
So wait, hold on a second, so other than Kerry. So let me ask you a question. Obviously, you can visually see with regard to our traffic expert that she may have some issue in being back here for the next meeting. So
I never presume anyone's condition.
Fair, very fair, and maybe that was erroneous for me to state. Nevertheless, what I would ask, Mr. Chairman, in deference to her, if it's possible, that should members of the public have questions for her,
Right.
that maybe we can extend tonight's meeting just for that sole purpose. There may not be any, but if there are.
Anybody from the public that has just a specific traffic question.
Correct, for Kerry Penke.
Let's get, because clearly
Yes.
I mean, that's fair enough. You guys, board doesn't have any problem doing that?
Mr. Chair, Mr. Gall is not available for the November 2nd date.
Whoever's talking, I can't hear.
I'm so sorry. Mr. Gall is not available for the November 2nd date.
That's,
Well, I guess you can ask whether any member of the public has a question for Mr. Gall.
Yeah,
But
so
let's-
why don't we open it just for, not for any comments, but only for questions of
questions
Ms.
for-
Penke and Mr. Gall.
the traffic engineer or questions for Mr. Gall? That's it.
So if anybody has any questions, not any comments, but any questions for Ms. Penke or Mr. Gall, please come up. Okay, please state and spell your name for the record and give us your address. And remember, this question is only.
Paige Hackett, 578 Newton's Corner Road, Paige-Hackett. I do have a question for Ms. Pankey.
Just right there.
My question is in regards to your traffic study. I've attended a lot of these meetings, and I might have missed it, but I don't think I've heard anything about the traffic coming off of 195 onto 547 Lakewood Ellenwood Road and the intersection at Herbertsville and Oakland Road. Was that under consideration in your traffic study?
It was not part of our scope of study.
Okay, so the main route that you're routing, that you're considering that these tractor trailers will be taking is from 195 off of the exit onto Lakewood Ellenwood Road, through that intersection straight, continuing down to Victory Road, correct?
Correct.
So you haven't looked at that intersection at all?
That's correct.
Okay, so I travel that road every day. That's how I get home from work. I take 195 south. Often traffic and the time from anywhere from 3:30 to 6 o'clock is backed up all the way to 195. It's a very, very dense intersection. I don't see any way that you could add that many tractor trailers through that intersection all day long, every day, especially during rush hour time. You haven't looked at it, so I guess you don't have an answer for it. That's my question to the board. It's a very, something that should be considered. The other, just kind of, it's not really a question for Ms. Pankey, but it's in regards to her previous testimony before the easement was considered. She mentioned that the right-turning tractor trailers onto 547 from Victory Road should be able to make that turn because school buses make that turn. What is the turning radius of a school bus?
The radiuses are different. I had said the tractor trailer could make the turn within the existing pavement area.
I'm sorry, what?
The tractor... Oh, my apologies. A tractor trailer can make the turn in the existing pavement area. Not that it was similar to a school bus, but the school bus also had issues making the turn without crossing over the center lines as well.
With respect, that wasn't your testimony. Your testimony was, I've seen school buses do it, tractor trailers can do it. You were comparing the two as being comparable. So that's just something I want to bring up to the board, that they are not comparable really at all. The turning radius of a school bus, and I'm going to bring it up because I looked it up, because I am not a traffic expert, nor do I know anything about school bus length or tractor trailers, but I looked it up, and a school bus is 20 to 30 feet, while a tractor trailer is 55 feet. So the difference from a school bus to a tractor trailer is very different, and not being a traffic expert, I would say not to compare the two. That's all. Thank you for your time, and I hope you do consider that intersection as being completely problematic to this plan. Thank you.
Okay, again, questions only to Ms. Pankey and to the objector's witness. Please state and spell your name for the record.
First name Ellsworth, E-L-L-S-W-O-R-T-H.
Okay, just get a little closer to the mic.
Last name Burrows, B-U-R-R-O-W-S.
And your address?
11 Amanda Lane.
Okay, do you have some questions?
Yes. About the traffic planning again, what I'm hearing is there wasn't any planning besides Victory Boulevard. The last person that was up brought up the Herbertsville 514. Also, you have to look at Maxim Southern and 547. Because now you're increasing traffic volume along this road that's already bobbled up from both directions. And there must be some kind of survey done for these roads. You can't just plop a bunch of trucks on the road and expect everybody to be content with the volume that's going to happen. On that road, there are sports fields, they have games, people come and go on these roads. Now you're putting tractor trailers in here where people are leaving with kids from games. How long is that going to take for people to go home and all get to fields? That's my concern. So, I would say if you guys are going to do anything, please also look at the traffic
Well,
plan.
no, this is for questions, so do you have a
Yes.
question of the
Know
witness?
if you guys are going to do a traffic survey for for that road completely, not just for Victory Boulevard. Victory Boulevard dumps on both 547 and Maxim Southern. So the traffic plan must comprise both of those things, and I would like to know if that's going to be done.
The scope of our study include both ends of Victory Road, so the Maxim Southern intersection as well as the Victory Road intersection, and the additional traffic associated with the warehouse. The intersection was expected to still operate at good levels of service on both ends.
It's not working right now, so I don't see how you...
Well, those are comments, so you have more questions. You'll have an opportunity to comment also, but
Okay.
this is just for the questions.
I understand it, but what I'm hearing is a survey's been done, but I don't think it's appropriate.
That's a comment. Do you have another question?
No, that's my question.
Okay. Well, she's answered. You may not like the answer, but that's her answer.
That doesn't make any sense to me. You can answer something without an appropriate answer. That doesn't make an answer.
No, that's an answer. It's an
No, no,
answer
no,
you're
no,
not
that's-
satisfied with.
No, that's an answer, but it doesn't answer the question. Answer the question.
Mr. Chair, the witness has answered.
The witness has given me an answer. The witness did not answer.
You asked if she performed that study.
An appropriate survey of the traffic. Is it appropriate?
So, I mean,
It should be,
so she did answer your question.
She did a survey.
Yeah. However, I mean,
We follow industry methodologies and standards when we prepare all our analysis.
no, what I was going to ask is, it seems that the last two questions, they may not understand what the requirement, like the scope of how far we go off-site, like what's
I can explain that real quick
pertinent.
if that would be helpful.
Yeah,
Okay.
maybe that's what you need to do.
So we determine study locations based on a significant impact, which is defined by New Jersey as 100 trips or more added to an intersection. We're actually, with this site, even to the two ends of Victory Road, don't add 100 trips, yet we still analyze those, which is why our scope doesn't have to go out further than that, because of that definition of a significant impact of traffic being 100 trips, new trips or more added to an intersection.
Better?
No, but I can't make a comment, so there's no point.
Okay, sir, state your name, spell it, and your address.
At 5 a.m. Whatever.
Well, it's a question, so I don't need to swear you in. But you do need to state and spell your name and give us your address.
104 Victory Road,
And your name, sir?
Nielsen, Nielson.
Your first name?
Darren,
Okay.
Darin.
Go ahead.
Okay, my question basically comes up from reality, living it, and the pictures of the drawing of the traffic, and hopefully you studied for it a little bit, because I did talk to you at the school over there, whatever. Okay, so you've come up with a very nice drawing of showing that this is where the front bumper is going to go, this is where the back tires are going to go, and being able to make a turn, right? Okay, so with that picture, which it looks beautiful in black and white, but then we also, I noticed we had an aerial picture of reality. Okay, there's a tree, there's a house, the farm with all the visual appendages to make it so that, one, if you go back to that picture of the black and white, that shows that, yep, you can make this turn without crossing that double yellow line. Okay, at what point, how far back from 547's yellow line, the center line, how far back is the white line or sidewalk going to have to be for this tractor trailer? And I'll really don't care if it's making a right or left, to be able to make that turn safely and be able to see oncoming traffic, and I don't care where it's coming from, north, south, east, or west. How can that be done safely? I know it can be done on a picture, but can it be done safely?
Before you answer the question, do you understand the question?
I'm not sure I'm understanding what you're
Okay,
asking.
let's start with, how far back is the truck going to have to be to make that turn? We'll say right. We'll say going to Lakewood on
Are you talking
547.
about the stop bar?
Excuse me?
Talking about the location of the stop bar?
What stop?
I think it'd be easier if you just break it up and ask Ms. Penke the question based on a specific location. So just identify the location you're talking about, and then ask her the question at that particular.
How many
location.
intersections are we talking about for this company that are going to get reconstructed?
Well, I think you have to repeat the question, please.
Are you familiar with the intersection that needs to be reconstructed to make this thing feasible?
The one on the screen, correct? The Lakewood, Farmingdale Road, and Victory Road
There you go.
intersection, correct? Okay.
Okay. Now, I'll let you pick a direction, going, what is that, east or west? How far back on Victory Road does we're calling it a stop bar, the sidewalk, the line crossing, okay? How far back does that truck need to stop to be able to facilitate this turn legally?
It'll be designed to industry standards to be able to accommodate.
Oh, I know
turn.
it'll be designed, okay. Now, is that design going to be legal? Is it going to be safe to be able to see with the bamboo farm and the tree and the house on the other side? We're talking about a tractor trailer that can't get to 0 to 60 in 5 seconds. So I'm saying things we need to look at is, one, the speed of the traffic on that road, and two, more importantly, how far back are we talking for that truck to be sitting back to be able to make that turn the way the picture shows it?
It'll be designed to the industry design standards, which will account for sight distance and all the requirements that we need to take into
Okay,
account.
I'd like feet, because I'm going to go out there with a measuring tape, and I'm going to make a little chalk line on the side of the road so that I can just physically see how this is going to even be done. Now, we talk about the buses and stuff like that. Well, buses are great because they have a stub nose, the long ones. Okay, the long ones have a stub nose. They can get right up there and they can see left and right. Tractor trailer, they've got a 10-foot extension on the front. It's called an engine, okay? You know how far back those things got to be to make this turn? That's a real question.
Do you understand the question?
I do. It'll all be on the design plans when the.
I rest my case. Thank you.
Okay, so there are any more questions for either of these two witnesses?
I'm wide awake now, man.
We don't see any, Mr. Chairman.
Yeah, no.
Mr. Chairman.
I was just going to say, anybody else have any questions for the traffic engineer?
Or
Or
the,
Mr. Gall?
yeah.
Okay. Seeing that there's none, I'm now closing the public portion,
For tonight.
Thank you
For
for
tonight.
the time. I appreciate it.
and good luck.
Thank
So,
you.
Mr. Simon, did you have an
Yeah,
opportunity?
I just want to have 2 minutes. or
Sure.
Maybe even 1 minute just to check in terms of availability of the remaining witnesses.
Yeah, go ahead.
Of course.
Thank you.
Sorry, you didn't get any questions.
Here's your pen back. That's okay.
You're very important to us.
Oh, no, I understand.
I don't feel left out.
Okay, good.
Well, that's it, we're done. Just waiting for him. The public's closed. I did, I asked the public. Public's closed. No, for now, for tonight. It's closed for night. Now we're waiting on Mr. Simon. No, because there's other questions.
Mr. Simon, are you ready?
November 2nd?
November,
November 2nd.
Yes.
okay,
That's
Mr. Chairman, they are good for November 2nd, so let me make the
Fantastic.
announcement.
Can you also grant the board an extension of time?
Yes, we will grant the board an extension of time through that next date, evening. Thanks.
Through November 3rd?
November 3rd, yes.
Thank you.
Okay, so the application SP 05 AAVR HW Properties LLC be carried to the board's November 2nd, 2023 meeting. Excuse me, that's a live meeting beginning 7 o'clock here in the main meeting room in Town Hall. There'll be no further notice to property owners. Also, all documents associated with the application are on file and available for inspection during normal business hours at the planning department. Again, there'll be no further notice to property owners.
Fantastic. Master plan?
We're going to have a public hearing on the re-exam at the 19th, so the next meeting.
Okay, and we have no reason to go into executive?
No, Mr. Chairman.
Okay. Need a motion to adjourn?
The conference in San Antonio.
All in favor? Adjourn.